We filed a petition on 12. There is a urgency. May I please, can it take?
Today, motion matter. What is the urgency?
Urgency, my lord, we are the third bidder. And we are asked to give the bid in a particular manner. Then our committee did not accept. Then
Which department?
my lord,
Which department?
fishery.
Inform them
I'll inform.
whether they
Now
are.
they have again retendered it.
Hmm,
It is opening on 22nd. But
okay.
they are not allowing me to participate in the tender because we have not followed their direction to give the tender in a particular manner. That cannot be
You should
done.
have got the information or consent of, because if you move unlisted, he has to be prepared.
I'll comment. I'll
Okay,
tell-
tentatively we allow you, but if he makes any objection, then we'll have it tomorrow.
Yes.
Okay. Right.
May I please, your Lordship. Lordship, I'm paying for listing of a matter, Lordship. The matter pertains to that Joymala elephant that is captive in Tamil Nadu, Lordship. There is some further development that the elephant is not, it still is under lots of pressure, under lots of actors and all.
Now, what is the urgency?
Lordship, we need some direction from this court. to
No,
release the
urgency. What is
elephant.
the urgency?
Direction from the court release the elephant to any of the welfare society, to any state, your Lordship.
Yes.
May it please the Lordship. My lord, on 11/1/2024,
Hmm.
my nomination was rejected. On 12, it was a holiday. Now 21st is the election, my lord.
Oh, election for?
My lord, that board of directors of cooperative society, can it be taken up tomorrow, my lord? Tomorrow, my lord.
Tomorrow.
Ma'am, madam, this is a compulsory appointment, madam. Maybe come up for admission next week, anything.
Compulsion repetition of which year?
It is a 22, man.
22.
20.
What is the stage?
The admission stage.
Next week. When?
Maybe at 24.
Try on 24th, okay.
Wait, please, your Lord.
Hello.
Item number 7 and 8 of your Lordship's daily list, my Lord.
Hmm.
And these matters are led by Mr. K.N. Chaudhary.
Yes.
He has expressed some personal difficulties, my Lord. So if it can be taken up,
Yes,
I've
Mr.
taken the
Pathak.
consent of the
When do
arbitrator.
you want?
Can it be in the mid of February, my Lord? 15th.
Suggest a date?
15th is a Thursday, Lordship, can be taken up and disposed.
15th of February. Okay. A prayer for adjournment has been made on behalf of Sri K.N. Chaudhary, Learned Senior Counsel for the petitioner. Also heard Sri K.P. Pathak, Learned Standing Counsel APDCL, full stop para, as agreed to by the Learned Counsel for the parties, list on 15/2. Is there an interim order?
There is an.
Interim order is in their favor also in my favor.
There are two
The
petitions.
inter-
There are-
the
My
interim.
Lord, my interim order, let it be, my Lord.
In the interim directions would continue till the next date of listing. 7 and 8, 15th of February. As the present for electricity number, okay, electricity ombudsman. No.
Maybe the Lordship. I beg to mention for listing, Lordship. The matter pertains to seeking direction to the register Qadi to register the votes to the petitioner, Lordship. Earlier also I mentioned, Lordship. Lordship, the petitioner is posted, he is a CRPO employee, he posted at Darkhan, Lordship. He has come to his home, Lordship. If any order is passed by this honorable court, then he will appear before the authority, Lord.
Repetition of which year?
23, Lord. 23 year, Lord.
Notice has been served.
Yes, Lord. Notice that.
Okay, we can have it on next Wednesday.
All right. Obliged.
May it please, your Lord. This is regarding a matter where my bid has been rejected during the technical bid evaluation process. Now, if your Lordship will kindly come to the
Which
bid document.
department? Which department?
Agriculture.
Who's there?
Vikram Chaudhary will be there.
Where is Mr. Chaudhary? B. Chaudhary? Yes, what has happened actually?
Yes, Lordship. This is regarding a particular aspect of the minimum eligibility qualification. If your Lordship will come to page 29, I'll just shortly place the facts and then On the basic aspect, I'll come, Lord.
Just a minute. Yes,
Page 29. This is for procurement of micronutrients.
Hmm.
And if at Lord's Lordship comment page 63, 63 is the required minimum experience. Now therein, we are manufacturer, page 63.
yes, 29.
29 is the bid starting document. This is for procurement of micronutrients.
Okay,
And the minimum eligibility or the minimum experience is at page 63. 4.2.1,
63.
63.
Madam Borua, where is Mr. B. Chaudhary?
Your lordship is on Lexington Code 26.
I'll just place the facts. I think by the time he may be able to read.
Let him come then.
As your lordship, please.
Now, what is the basic issue now? What is the, you are a
The basic-
manufacturer?
Yes, the basic issue is what was required under the minimum eligibility or minimum experience was the particular product for which they have asked for this procurement. Now, as a manufacturer, I'm supposed to produce double that amount that has been required in the last 5 years. Now, the issue is the particular product is zinc sulfate. Now, zinc sulfate, they have categorized it as zinc sulfate heptahydrate. Hepta means 7 molecules of water into it. And what they are now saying is, now we are manufacturers of zinc sulfate.
Hmm.
Now, these are different flavors of zinc sulfate, I would say.
Hmm.
One is zinc sulfate heptahydrate, and the other is zinc sulfate monohydrate. Mono is 1 molecule of water. And what has been required is heptahydrate is 7 molecules of water.
Hmm.
But if you lordship will see the technical specification, lordship is given the NIT itself, it indicates that the matter is zinc and sulfate, wherein 7 molecules of water is added, then it becomes heptahydrate. If 1 molecule of water is added to it, it becomes monohydrate. Now, what we have given is, we have given for only 3 years. They have said 5 years double. We as a company, we have given our data of production for 3 years, wherein we have categorized this particular zinc sulfate into 2 heads: zinc sulfate heptahydrate, zinc sulfate monohydrate. And our figure reaches more than the double amount. Now, during the bid evaluation criteria process, what they have done is, they have said that no, we had asked for zinc sulfate heptahydrate, but you have given your list for both monohydrate and heptahydrate. Therefore, they have rejected. My basic contention is that the chemical composition is zinc sulfate. Now, you are just adding a flavor to it by putting 7 molecules of water or 1 molecule of water. Now, on that particular ground, our bid rejection should not have been logical or reasonable in my humble opinion, because we are a manufacturer. We are in manufacturing business of zinc sulfate. In 3 years, we have crossed that amount of what they have stated. But we have given it in 2 different headings: zinc sulfate monohydrate, zinc sulfate heptahydrate. That particular, your lordship will find at page 195. And we have replied to them. They have also counter replied to us. Those documents are there. Page 195. This is the production, declaration of production. This is ultimately zinc sulfate heptahydrate, zinc sulfate monohydrate in that. Page 195. Next read. Now, they have said for 5 years, 2018 to 2023. Now, we have given for 3 years, and in 3 years only, we meet that particular amount. If zinc sulfate, both the categories are taken into account. Because ultimately, the technical specification, as they have also given, that your lordship will find at page 65, it is ultimately zinc sulfate. So, lordship will again come to page 65. The schedule of requirements is there. I'll just place 65 and then I'll come to again 195 note, page 65. Details of requirement. That's just in there. Micronutrients, zinc sulfate, heptahydrate 21%. Now the technical specification is there, just below.
Yes.
The technical specification indicates that zinc sulfate contains of zinc and sulfate, sulfur. Rest is pH, lead, cadmium, arsenic. These are all poisons otherwise, but in very minuscule proportion. So ultimately, zinc sulfate is basically a chemical composition of zinc and sulfate. Now, when we add 1 molecule of water to it, it becomes monohydrate. And when we add 7 molecules, it becomes heptahydrate. I've checked up in Google also this aspect, what I'm stating. And at page 195 is what we have declared. We are
See,
manifesting.
we have not heard Mr. Chaudhary.
Yes,
Your explanation is that you produce the basic product which you are terming to be zinc sulfate.
zinc sulfate.
And hepta and mono are two maybe subheads under zinc sulfate.
Zinc sulfate.
So your contention is since you are have the experience or fulfill the requirements so far
Yes.
as zinc sulfate is concerned,
My production
your overall
capacity can meet
production should be
this.
taken into consideration.
Yes.
But we
their-
do not know what will be there.
Their argument is already available in page
The
112.
zinc sulfate itself is a is independent product.
Yes. Zinc sulfate is two aspects. Zinc.
No,
and-
no, zinc sulfate heptahydrate
Yes.
itself is the requirement. They'll stick to the requirement.
That is their argument. Their argument is that
Let him come.
we want the quoted item only. But my contention is that we as a manufacturing unit has the capacity to manufacture. So if this could have been considered, we have given a competitive
him
rate
come,
and we
let
could
him
have been
come.
L1.
Let him come.
Yes, doctor.
Mr. Gogoi, please inform Mr. Chaudhary. Okay. 18.
Please, your lordship. My lord, a tender notice, e-bid notice was floated for grant of IMFL retail off license, my lord, wherein the petitioner participated, my lord. My lord, the clause 10.2.2 at page 33 provides that, my lord, the bidder shall submit both technical and financial bids through online. So the petitioner, along with two other tenderers, my lord, submitted their bid online, my lord, online bid. It and that particular clause further stipulates that one hard copy of technical bid along with supporting documents, application fee, EMD affidavit, and undertaking in original and other self-attested documents shall be submitted in the envelope containing the technical bid and clearly marked hard copy of technical bid. So that hard copy, my lord, the petitioner went to submit, my lord. There was no any drop box, my lord. So he submitted to the one official of the excise branch, my lord. Now, my lord, his bid has been rejected on the ground that he has not submitted the hard copy of the technical bid. And clause 10.2.2, my lord, further stipulates that in the event of discrepancy between online and hard copy of technical bid, the online bid shall prevail and shall be considered for evaluation. Because, my lord, now the case of the petitioner is that, my lord, the respondent authority is in collision with the private respondent, my lord. They have, my lord, because other two tenderers, my lord, there were three tenderers, the petitioner along with one another, both their technical bids have been rejected, my lord. The case of the petitioner is the improper rejection of his technical bid as well as improper acceptance of the technical bid of the respondent number 4. Because, my lord, as per the tender conditions, a tenderer has to submit a no dues electricity certificate, my lord. That he has not submitted. And secondly, my lord, if your lordship peruses page 63, my lord, a medical fitness certificate he has to produce. The respondent number 4, page 63, my lord. And that medical certificate duly certified by a MBBS doctor, my lord. But in the instead case, if your lordship peruses page 63, this certificate is by a dental surgeon, my lord. Down below in the note, my lord, your lordship will find that medical practitioner holding at least MBBS degree. But he has submitted the fitness certificate of a BDS doctor, my lord. And that fitness certificate has to be submitted in terms of clause 6.2.19 of the tender documents, my lord.
Where is the statement that you have submitted your
Technical
hard
bid,
copy
hard copy, my
of the
lord.
technical bid?
Yes, my lord. I have stated in many paragraphs, my lord, I have stated in paragraph 4, my lord, specifically.
Paragraph 4,
Paragraph 4, my lord.
page,
Page 5.
okay.
Page 5, my lord. Paragraph 4, and then my
Building assistant.
specific statement at page 5, my lord. The petitioner in strict compliance of the aforesaid clause so-and-so submitted a hard copy of her technical bid by clearly marking so-and-so in the excise branch of the office of the restaurant number 3 on 21/12/2023 itself. Since there was no Dropbox for submission of the said hard copy of technical bid, the petitioner submitted the same to a dealing assistant in the excise branch of the restaurant number 3. Although the petitioner requested for an acknowledgement receipt to that effect, however, the state billing assistant refused to issue the same and assured the petitioner that the same will be placed along with her bid. My lord, my humble submission is that 10.2.2, my lord, last line, my lord, in the event of discrepancy between online and hard copy of technical bid, assuming that, my lord, that was not available, but because the petitioner submitted, but they have in a pre-planned manner, my lord, somehow to.
Okay, yes, yes, Mr. Gupta.
My lord, may kindly peruse, my lord, page 21 and 35, my lord.
21.
21 is the schedule, my lord. Serial number 9 is the closing date for submission of e-bid. That was 21/12/2023.
Where is it?
Page 21, my lord, in the table, my lord.
Number 9.
Number 9, my lord. Closing date for submission of e-bid, 21/12/2023. If my lord now peruses to page 35, my lord. 10.5.6. The envelope marked
Page
35.
35.
35.
Yes, please. Yes.
It says, my lord, the envelope marked as hard copy of technical qualification bid shall be deposited at the designated seal box at the office of the district collector before the end date and time of submission. That means before 21/12/2023. Now, my lord, the question of discrepancy will come when there are two copies available. If a copy is not available, the hard copy is not available, the question of discrepancy will never come. It is permissible if there is discrepancy that will, my lord, rely on the online copy. My lord. There is a case, my lord, there is no hard copy. So the question of discrepancy will never arise, my lord, because there is other copy is not available. If now, my lord, there is my instruction, my lord.
Yes, instructions.
Yes, my lord.
Please.
With reference to the subject cited above, I have the honor to inform you that e-bid application was called for grant of IMFL off-top in respect of sub number so-and-so at Harupetia Municipal Court. Altogether, 3 online applications were received. However, a hard copy of 1 application was not received within the stipulated time. Srimati Anjana Das, that's the petitioner, my lord, tried to submit the hard copy of the technical bid on 27/12/2023 at around 1 p.m. Hence, her hard copy was not received by the department. It is to be mentioned that the last date of submission of hard copy of technical bid was 21/12/20 as per clause number 7. Then, my lord, there is one more discrepancy, my lord. There are 2 annexures to the to the tender document, my lord. That is page 52 and 53. If my lord peruses from the repetition, my lord. These are the two.
Just a minute. 20. Page
52 and 53 of the repetition, my lord. These are annexure D and annexure E to the tender form, my lord.
52. Yes, 52.
52 is the, my lord, format for undertaking by bidder to be uploaded by the bidder. That's an undertaking. And 53, my lord, will kindly see, that's a technical bid submission certificate.
Yes.
These 2 were also not submitted by the petitioner, my lord. That, my lord, finds in my instruction at 2nd page, my lord. These two vital documents were also not submitted by the petitioner.
Okay,
My written instruction, my lord.
okay.
Second page, in the
Mhm.
online technical piece, Srimati Sorensen did not submit some of the most important mandatory documents
Okay,
such as Annexure D and E. If now my lord peruses my written instruction for a moment, my lord, the
yes.
third page, my letter of acceptance has already been issued, my lord.
Okay.
And my lord, the successful bidder, the private respondent, has already deposited next page, my lord, the bid value of 26,50,000, my lord. Plus, my lord, 1 lakh application fee form, my lord, fee. So around 27.5 lakh, 50,000.
How do you meet his arguments regarding the
Medical
defects in the bid of the private respondent?
Private respondent bid, there is one defect that instead of
Medical.
MBBS, it was done by BDS. my lord.
And
Big defect.
another,
Big
that
defect.
no dues electricity
No, no,
certificate.
that I have already, in case my lord, this is my written instruction, my lord. No, that is second note of my lord.
We'll
And
come-
one
we'll-
more
We'll
dispute.
come back. we'll come
Yes,
back.
my lord.
Second paragraph of my written instruction, my lord.
Okay, we'll do one thing. You serve Dusty on the response number 4.
Yes, my lord.
We'll not pass any interim order, but we'll try to dispose this matter.
My lord, at this
Or
status
notice on
quo, my
injury-
lord,
notice
because
on
my
injury,
lord,
my
the
lord.
petitioner quoted much higher rate, my lord.
It is
36
okay,
lakh.
we'll.
And secondly,
No,
it
Mr.
is-
Mr. Bora, we are not
my lord, it is-
disallowing or rejecting your interim prayer. We'll issue notice on the interim prayer.
but my lord, status otherwise, my lord, if they start their business, my
Yes,
lord.
We'll make
is
some
for 1 year.
observation, we'll make some observation.
Yes, my lord.
Any action taken would be at the risk and cost.
And secondly,
But
my lord,
there is one point you'll have to meet. We can make it very clear now.
yes,
On the behest of an unsuccessful bidder, we may not even go into the aspect of legality of the process.
yes, my lord.
Unsuccessful in the sense, a disqualified bidder because of not meeting the eligibility criterion.
My lord, that is the case of the petitioner that there was no drop box, my lord. Because as per the tender condition, there should have been, that I
No.
have specifically mentioned at that paragraph.
Mr. Bora,
Basic, my lord.
Mr. Bora, there are two aspects.
Yes, my lord.
Which we'd like to have your response.
Yes, my
The
lord.
last date was 21/12.
Yes, my lord.
Okay, and as per their instructions, we do not know how far the instructions are correct,
Yes,
but whatever is placed on record today, we have to take it on
Yes,
its face value.
Because I cannot prove
No,
that they are.
no.
Yes, madam.
Listen to the quote. Your the instruction says that you tried to submit the hard copy on 27/12, which is beyond the
madam.
date prescribed, number
Yes,
one.
Yes,
Even if we accept your version to be correct, that you had gone there was no drop box, and you had tried to give on a dealing assistant, he did not issue any acknowledgement. We have read that.
yes, my lord.
But that is after the last date. So whether you had gone there,
On 21/12, I have specifically stated, my lord, on oath, my lord.
we'll see there. And what about the not meeting the format at page 52, 53?
My lord, that is not correct because, my lord, regarding that,
You produce the records.
yes, my lord. And with a spotted, and my lord, till that status quo, if I am not successful, my lord, then obviously he will get, my lord.
Person has already deposited 27.5 lakhs, my lord.
I have also deposited, my lord, 1 lakh application fees, 5 lakh security
That
money,
will
and
be refunded, my lord.
not
And
security
this
money
license
will
is only
be
for 1
refunded.
And Mr. Goswami, there's also one point you have to meet, which Mr. Bora has not argued or how many bidders were there?
Free.
2 have been disqualified.
Yes,
Disqualified.
Can you go ahead with one?
That's an issue, my lord, because
Yes, my
it's an
lord.
auction process. Definitely there has to be.
No, there has been some dilution in the process.
Yes, my lord.
The strict application of CVC, but CVC also said that after the second time you can certainly
Yes.
go, but first time you cannot.
Yes, my lord. At
They should have gone
least
for
three
He has
bids.
not argued this, but you take instruction. There may be
Okay.
some new guidelines which you are not,
I will take.
but even if he's not argued, a law point of law, we'll try to have your
Because
response.
that being as, my lord, auction process, there has to be some
Some
competitiveness.
yes. And only to avoid creation of any cartel or any monopoly, this guidelines have been incorporated. That first time at least, single bidder, no.
Yes,
Second
my
time, if the same situation agrees, then it may be a case that others may not be interested.
Yes.
For that public interest to not suffer, you go ahead.
Yes.
Third, three.
Spot date may be given.
Yes, where is the place?
Romeo, Mongol, my lord.
Harupetia.
Harupetia.
Yes, my lord.
Doron district, Mongol.
Dorong district, Kharupetia. Page 15, my lord. It is clear.
Private respondent is where?
Private respondent is also from Kharupetia, my lord.
You are from Kharupetia?
Yes, my lord. There are two private respondents, my lord. Other two bidders, my lord.
It's given to whom? R4?
I respond number 4, my lord.
Okay. Heard Sri DP Boras, Learned Counsel for the petitioner. Full stop. The petitioner has put to challenge a process, put to challenge the decision-making process pertaining to an NIT dated
2011-2023, my lord.
2011-2023 pertaining to an online
Yes,
or,
lord.
on shop or what?
Yes.
IMFL license.
Off.
IMFL off license at Kharupetia in the district of Dorong. Full stop.
Kharupetia, ward number 5, my lord.
It is the case of the petitioner that both the technical and financial bids were to be submitted online as well as online, full stop. It is also a stipulation that the hard copy of the technical bid along with the supporting documents were to be submitted before the closing date, full stop. Sri Bora submits that though the online bids were submitted, though both the technical and financial bids were submitted by the petitioner online, her endeavor to submit hard copy of the technical bid was not successful, as there was no Dropbox and though the copy was handed over to a dealing assistant of the office, no acknowledgement of receipt was issued, full stop. It is also pointed out that apart from the issue of rejection of the bid of the petitioner, the bid of the successful bidder, that is respondent number 4, was also defective, as the no dues electricity certificate as well as was not submitted, full stop. It is also the specific case of the petitioner that the medical fitness certificate of the respondent number 4, which is the requirement of the tender conditions, is not issued by the appropriate authority, but by a dental surgeon,
And
which is in violation of clause 6.2.19.
And one more aspect, my lord. The site plan duly prepared by a technically competent person, non below the rank of SDO PWD department, has to be submitted. But he submitted, which was
Submissions have also been made citing defects on the submission, on the aspect of the site plan. Full stop. Para. Sri Goswami, the Learned Standing Counsel. Excise Department, on the other hand, has submitted, by relying upon the written instructions, has submitted that as per clause 10.5.6, the hard copy of the technical bid was to be submitted before the end date, which was stipulated as 21/12/2023. And such and as per the instructions, comma, the attempt to submit hard copy by the petitioner was only on 27/12/2023, which was accordingly not accepted. Full stop. Issue regarding non-submission of the format of the undertaking in the prescribed format and also the format under Annexure E have also been raised. Full stop. It is also submitted that in the meantime, comma, on 17/1/2023, 2024, comma,
Yesterday, my lord.
the LOA has been issued in favor of the respondent number 4. And the said respondent has also made the, what deposit? Deposited the bid value
Of 26 lakh.
of about rupees 26 lakhs approximately.
50,000.
Full stop, para. Let notice be issued. Returnable on, yes,
Yes, my lord.
yes, tell us a date.
23rd month.
23rd, January.
Or my lord.
No, he has to take Dusty.
Yes, my lord.
Then my lord, 1st or 2nd of February.
2nd of February, can
Right.
you come
Right.
on 2/2/2024? Sri Goswami, the Learned Standing Council accepts notice on behalf of
One,
the
two, and
respondent
three.
numbers 1,
2 and 3.
2, and 3. Full stop. Steps for service of notice, registered post AD. Subset 2, very Dusty. Same routed notice of date or proof of very affidavit. Full stop. Para. Sri Bora, Learned Counsel for the petitioner, prays for an interim order. Full stop. Para. The aforesaid interim order, the aforesaid prayer would be reconsidered on the returnable date. Full stop. It is however made clear that any action taken in the meantime would be at the risk and cost of the concerned parties and subject to final order, subject to further orders that may be passed by this court. That report liখিব notice or report. There is one more aspect
My lord,
in
may-
this matter with regard to the situation wherein only one bid was found to be
Yes,
technically
cannot be required because one was rejected at technical stage, other was rejected at the bidding.
No, my lord.
That is page 60, my lord, precise
60.
60.
Now, in the financial bids, how many tenders are there?
No, one, two.
60, page 60.
Page 58, it starts, my lord, the minor. 57, my lord. Page 57, annexure 4, third paragraph, my lord.
No, we'll record your submission also.
No, it's.
We'll
clear,
record your submission also. We'll see from the record.
Right.
There may be one more aspect in the matter regarding regarding emergence of a situation of only one bid, full stop. Full stop. Sri Goswami, however, clarifies that
My lord,
in the
can you- page 61, my lord, that is clear.
we have
my lord.
not said anything, Mr.
Yes,
Bora.
sir.
Just have
Yes,
your
sir.
patience.
Yes, my lord, sorry, my lord, sorry.
However, clarifies that in the financial evaluation, comma, there were two bidders, full stop.
Right.
Para, bidder as it may, comma, this
Right.
aspect of this matter would also be considered on the next returnable date. Full stop.
Oh, yeah, right.
Our notice of episode, the records of the decision-making process are also directed to be produced on the next date. We'll examine that aspect.
True.
You
My
may
lord,
be
if the
correct, you may be correct.
Page 61, it is clearly stated.
We
that-
have not, have we said that we have rejected?
Yes, no,
In fact, we have not raised this point, we'll see.
yes, my lord.
Still we'll see. This one can keep,
My lord, may keep it.
Obliged, my lord.
but you take steps immediately, Mr. Bora.
In an auction process, my lord,
Yes, sir.
apparently there cannot be only one bidder. my lord. That will be no auction.
Obliged, my lord.
Item 17.
You must have gone through the petition.
Yes, yes, my.
He is trying to build up a case that he has the minimum experience, the required experience, so far as zinc sulfate is concerned, the broader component. You want zinc sulfate, heptahydrate, for which he does not have that minimum thing, but he has the overall capacity so far as zinc sulfate hepta and zinc sulfate monohydrate is concerned. What is your response? Are these two separate, totally entirely different aspects or components or ingredients? Or can you take it
Chemical
together?
composition is the same.
Wait, we have heard you. Yes.
Lordship, my information and instruction is that it's a completely different item, Lordship. And in the tender, Lordship, it has been specifically stated that they must have the capacity of manufacturing of the coated item. Lordship, another similar item, that aspect cannot be taken into account while deciding their or evaluating their manufacturing
What is
capability.
the stage of the evaluation, tender process?
Lordship, subsequent to the orders in the other cases, Lordship, financial bid has also been open, but
it's kept
that
under-
has not been made visible since the other cases are pending, Lordship. That supply condition, Lordship, today, those are listed.
We had passed some judgments here in this by this court.
Yes, Lordship, the initial interim order was subsequently modified.
So the
103 I have
matters
annexed.
where Mr. Khatoniar was arguing, those matters are connected or what?
No, not that one, Lordship, where senior counsel M.K. Chaudhary is appearing.
Page 203, I have annexed that order.
Lordship, that
Wherein-
minutes of the financial bid.
The
Lordship,
judgment has been delivered or no?
No, it's still pending. Lordship. The minutes
What
that
was
has
the
been
name?
kept in the seal cover, Lordship, that matters.
Financial bills have been open. It is otherwise kept in steel cover. Before your lordship, the matters are there today. My entire contention is, if otherwise I would not have been technically disqualified, I have put out a very
No, aren't
concrete
you
inquiry.
late in coming to the court?
Late would mean they have replied to
No,
me.
those matters have been heard and the financial bids
Yes,
have
that
been.
is true. That is true. But
Will issue notice at this stage. Heard Sri A. Sharma Learned Counsel for the petitioner. Full stop. The petitioner which is a.
manufacturer.
Oh, no. Oh, you are a what? Proprietorship firm or what? Which is you are not a company. What are you? Proprietorship firm.
Proprietorship.
What is a proprietorship company? What kind of drafting is this? Paragraph 1. Can a proprietorship be a company?
No, cannot be a company. I seek apology. The proprietorship
Is a
concern.
proprietorship firm
Con-
which had participated in a notice inviting tender dated 29/9/2023 issued by the Director of Agriculture. Full stop. The specific case of the petitioner is that the requirement of experience qua a manufacturer like the petitioner is met by the petitioner, in as much as the data given to the authorities pertains to zinc sulfate, which includes zinc sulfate heptahydrate 21% and zinc sulfate monohydrate 33%. Full stop. It is submitted that the overall experience should have been taken into consideration, in which case the petitioner would have been termed to be technically responsive. Full stop. Para. Sri B. Chaudhary, Learned Standing Counsel of the Standing Counsel, Agriculture Department, however, submits that apart from the delay in approaching the court, there have been developments in the form of litigations on this particular NIT, and in terms of orders passed in those cases, comma, the financial evaluation is also done, which however is kept in a seal cover. Full stop para. Let notice be issued. Returnable by 4 weeks. 3. Chaudhary, London Standing Council, access for all the
All the
respondents, extra copies. List along with when? List along with WPC?
658, but that matter is today, I think.
Today listed, sir.
Carter.
Before this, report, sir.
আজি কিহৰ কাৰণে আছিলে?
For admission hearing, sir.
Last date we had passed some orders. What was the orders?
Lordship has modified the earlier interim order, directing the authorities to go for
Page
those.
207.
Tag along with WPC swings.
658.
Okay. Keep a track of those matters.
Yes. Another aspect is the financial bid is already open. It is there in steel cover. If I know that L1 bidder's rate, and if my rate is below that, I mean above that, then I don't have any case. But if it's below that, maybe I have
Let
a
us
case.
see. Okay.
Obliged or not.
Okay.
But this matter was filed in the wake of M. Krishnan judgment, where my lord, it was said by the apex court that consumer forums will not have jurisdiction because there is an arbitration clause. But then that judgment, my lord, has been overruled in 2022, my lord. But by saying that Consumer Protection acting as special law, even though there is a remedy of arbitration, consumer forums would have jurisdiction. So in view of that, my lord, I am withdrawing this matter.
Okay. Heard Sri B. Pathak, Learned Counsel for the petitioner, BSNL, full stop. The grievance raised in this petition was with regard to certain orders passed by the District Consumer Disputes Redressal Forum, Tinsukia.
My lord.
Tinsukia. In a consumer case whereby compensation was awarded in a dispute regarding telephone bills. Full stop. The challenge was structured in view of the law laid down by the Honorable Supreme Court in the case of General Manager, Telecom versus M. Krishnan and another, reported in 2009, 8 SCC 481. Full stop. Para. Sri Pathak, the Learned Counsel, has, however, fairly submitted that during the pendency of this writ petition, the larger bench of the Honorable Supreme Court in the case of Vodafone so-and-so reported in 2022, 6 SCC 496 has overruled the earlier view expressed in M. Krishnan Supra by holding that since the Consumer Protection So-and-so Act is a special enactment, the same would prevail upon the general clauses which governs the parties. Full stop. Para. In view of the aforesaid submission and the law settled by the Honorable Supreme Court, this court is of the opinion that the instant challenge may not be maintainable, and accordingly the writ petition is dismissed. Okay. You can take this or let it remain. Mr. Pathak, if you intend to file an appeal against the order of the forum, have you done that?
My lord, I have to take instructions on that.
Because it has come up suddenly today, my lord.
We'll make an observation.
Right.
In case the petitioner wants to avail the remedy in law under the particular enactment, comma, the fact of pendency of this case may be taken as a ground to explain the delay.
Clear.
Yes.
May I please your lordship? Lordship, Mr. R. Purvachari appears for this matter. Your lordship is in bereavement. I pray for your lordship to adjourn the matter for the day.
Okay. When can we, Mr. Sayola? When?
Any day, my
Lordship, the
lord.
matter may be fixed any day next week.
Next week? Okay. A prayer for adjournment has been made on behalf of Sri R. Borpujari, learned counsel for the petitioner, full stop. Also heard Sri G. N. Saheola, learned senior counsel, assisted by Sri B. K. Das for the respondent number 2.
Yeah.
Who is 2?
ONGC.
ONGC, full stop para. In the interest of justice, the petition, the case is adjourned to be listed on
25th, my lord.
25th is okay, madam? 25th. 25th one.
Plus,
May I please your lordship? Lordship, my senior, and that is Mr. Yukinar, was appearing this matter. Lordship, we need to take instructions from the client whether they want to continue with us or they want to change. Kindly 2 weeks time may be granted.
PWD. You have a PWD. You have not filed, you have filed your affidavit. Have you filed your affidavit?
No, but
Why? Who is R6? R6, yes, you have filed.
they have filed.
You filed your affidavit. R6 has filed if R6 is the executive engineer. Why are you saying, madam, not filed?
File is not a.
What is the issue?
Non-payment of contractual dues, lordship.
Non-payment matter is pending since 15. Why? Oh, there's an order denying the payment. You are challenging the validity of that order.
Yes, lordship.
Yes, madam, what is your stand?
But file is not available, right?
Why? Get your file.
But my name is not that spot.
Does not matter, it will not make any difference. Have the brief or not?
Yes.
Whether your name is there or not, if you are instructed, we'll record. Madam, you come prepared, we'll try to give her an opportunity to engage anybody. Otherwise, you argue on your own. These are all matters, we cannot keep this pending. What is your name?
D. Mohantot.
Sri D.
D.
MSD Mahanta Learned Counsel submits that due to change in the situation regarding the senior counsel who was earlier appearing, comma, there may be a requirement to engage new set of counsel, full stop. Miss M. Das, Learned, your standing counsel PWD is present, full stop, para, in the interest of justice. List on when?
2 weeks.
20? 2 weeks. These are old matters. We cannot list on 1st of February. Get instructions.
Much obliged, lordship.
And Madam Das, you take the court file if you don't have the file. You make your thing ready. Okay, next.
Obliged.
Item 4.
May it please your lordship. My lord, the petition is against an award passed by the learned labor court
Yes.
The award your lordship will find at page 58.
Mr. Chakraborty for the workmen. You're for the workmen?
Yes, ma'am. This is not a case of reinstatement.
It's a case where the labor court has determined that the contract laborer, who my learned friends are representing, were terminated illegally and therefore they are entitled to compensation.
Okay,
And a sum of rupees 75,000 each has been awarded.
okay. You are agreed by that.
I am agreed by that.
What are your main grounds?
There were principally two grounds urged before the labor court that the application was not maintainable because they did not come through a process initiated under section 10.
It
And
was not a reference.
It was not a reference. They approached directly to the court.
Directly
So-
means?
They filed an application
Under
before the,
2A,
under
No,
2A.
2A, it's limited, confined.
Yes,
termination of service.
Was it termination?
Yeah, they were
Because-
disengaged.
that was one ground. Second ground is that they were employed under contract labor. They were true contract labor. There was no master-servant relationship. And therefore, the proceeding was not maintained. Now,
2A probably will, you may not have too much of a legal stand. First point, 2A is very clear. Individual disputes can be raised. You are not necessary to be,
No.
your grievances to be espoused by a union.
no, individual, if it would have been a case of an individual, this could have been a different thing.
They have come
They-
individually,
No, they came in a group.
group but individually named.
Individually, there's a group.
They came as a group. Now, whether section 2A will permit a movement of an application at the instance of a group of employees. That
No, you
has-
see, it's just like a writ petition by an association or a writ petition by a number of persons who have joined together and filed a common writ petition. That we may not be too much. And
Then-
these are matters of interpretation of in the ID Act.
No,
These
then-
kind of technical things we may not, of course, yes. If it was not a case of, suppose a case of transfer or any other change of service condition, then an individual comes. You say you cannot come. You have a section 10 remedy. It has to be espoused in a representative capacity by the union or an
Now-
association.
Now, the other ground urged was that,
Labor, contract labor. You are not the principal employer.
yes, I'm not the principal employer, and they also admitted it during their evidence. They also admitted it in
But
the-
what about the ultimate, after the analysis, the direction? Direction is not for reinstatement, which,
No, but then if an amount of compensation is to be paid, there were around 20 employees, around 20 employees and 75,000 each. Now, unless
how
and
much?
until,
75,000.
yes, unless and until there is some responsibility on me, I have some relationship with the employee. Now, to undertake this burden is unnecessary, unjustified.
Well, here,
And-
but Mr. Chakraborty is not, in fact, challenging the order of compensation. He could have come, no, yes, I want reinstatement. But you are more or less agreeing with
Agreed with the
compensation.
But
And
the
I
fact
think,
that labor court has categorically
I
found,
think that Panitola case is also there, that compensation can be also
Yes.
given.
And
Panitola,
the-
I think, na? Panitola.
the labor court has categorically held that they are the employees of the principal employer because the contract
Okay.
could not be
Okay,
established.
Now,
okay,
now
okay.
that is another ground that the labor court has said that the contract, I mean, the agreement is a sham, although there was no issue framed on that line.
Which agreement?
The labor court has said that the agreement between the contractor and the management, that is us, is a sham one. Now, if it was to be a point of determination, then an issue ought to have been framed. Then in that respect, we would have been entitled to lead evidence. There was no issue framed on this point. And abruptly, the finding comes that the contract is sham. So regardless of the fact that whether or not they are our employee or contractor's employee, this issue becomes a bone of contention between the party. And therefore, it was
Okay,
incumbent
okay,
upon
okay,
the
okay,
labor court.
Okay, okay.
Now, your lordship will kindly find the award that starts from page 50.
50.
Starts from page 50, but your lordship can skip it over for page 56.
Just a minute. Petitioner is the management.
page 56.
Just a minute. Five, six,
56. Para 4.
just a minute. It starts at which page?
It
49?
starts at page 49,
Okay,
50.
50. Award dated?
Award
25,
dated 25/11,
11.
2014.
Reference case?
3 of 2014.
It's under 2A only, it's registered under 2A. Why are you harping on the first issue?
No, registered of the, because your lordship
We
will
thought it
kindly,
was under 10.
no, your lordship will kindly see, 2A in my respectful submission is an enabling clause. It's an enabling clause which permits filing of an application directly without going through the process of section 10. But it speaks of an workman, not a group. I'll just try to place it before your lordship. Your lordship may consider that. 2A subclause 2 says, notwithstanding anything contained in section 10, any such workman, it is in singular term, as specified in subsection 1, may make an application direct to the labor court or tribunal for adjudication of the dispute referred to therein after the expiry of 45 days from the date he has made the application to the conciliation officer. Now, the requirement of waiting for 45 days or waiting for the decision of the conciliation officer, these are also not properly followed, regardless of the fact that whether or not they can espouse the cause directly.
Okay, just a minute.
And two of them did not pursue the case even.
Those names will be struck off.
So your lordship, I'll just read it from the para 4, page 56.
Just a minute, just a minute. Para?
Para 4 of the judgment.
Page?
Page 56.
Yes, please. The
pleading-
issues.
Upon the pleading of the parties, the following issues have been framed for just decision of case. Whether the workmen numbers 1 to 15 are contract laborers engaged by the labor contractor. Now, here your lordship may note that the respondent number 5 and 13,
Yes.
they did not even file any application before conciliation officer. Because for that it says that at least an application has to be there. Whether the workmen number 1 to 15 are contract laborers engaged by the labor contractor, whether the labor contractor is a necessary party to the instant proceeding, if yes, whether the present proceeding is bad for non-joinder of the labor contractor as a party, and what are the relief. Now, your lordship can skip over for the time being the subsequent paragraphs and come to para 8 at page 58.
Which of the two respondents did not file?
5 and 13. Respondent number 5 and 13, I have pleaded that in paragraph 11, page 10 of the writ petition.
Paragraph?
Paragraph 11 at page 10 of the writ petition. And there is no denial.
Now you want us to go to page?
Page 10, paragraph 11.
No, that we have sent in the
in the judgment, paragraph 8 at page 58.
Yes, please.
To ascertain the above issue, let us discuss the evidence on record. Ghanshyam Vaishya, the workman, was examined as workman's witness number 1. In his deposition, he has stated that he is a permanent workman of Messrs. Imami and his designation is workman. There is a trade union of the workers by name Imami Limited Company, Shramik Union, bearing registration number so and so. It is the sole and recognized trade union of the establishment. His union has directed him to appear in the case as witness and depose from the union in favor of the workman. The terminated workmen were regularly attended in production manufacturing work of the factory as operator, raw material feeder, line leader, worker, etc. under direct supervision and control of permanent employees of Imami Limited. The factory of so-and-so was started with 54 permanent and 146 temporary workmen in 2004. There is no trade union till 2013. Initiative for formation of a trade union was started but failed, and after several meetings in a general meeting of the workmen held on so-and-so, a trade union was formed by adopting resolution. In the state meeting, the terminated workmen were present, and one of them, Sri Babul Vaishya, was elected as an executive member of the union. The proceeding was recorded and attendance of the workmen in the state general meeting held on so-and-so. The management was not happy at all in the event of formation of trade union, and after receiving details from labor inspector about the application for trade union registration, the management at a sudden debarred entry into factory for some selective workmen with effect from so-and-so. By the union letter dated so-and-so, the union requested to issue an order to their so-called labor contractor to comply with some statutory requirements. But till date, the management has not taken any step, and they hold that there is no independent labor contractor at Imami Limited. All are done itself by the management in the name of labor contractor. In the cross-examination, he has admitted that he has not filed the case. On request of the union, he has come to the court to depose in this case. He is not the president and secretary of the union. He has no knowledge of English language. He is the regular employee of so-and-so. He has not submitted registration certificate and constitution of union. He has not submitted any document to show that 15 numbers of workmen of this case are members of Imami Company Limited Companies Shramik Union. He knows that 15 numbers of workmen of this case worked under the contractor. The name of the contractor is Mr. Chandan Kakote, and these 15 workmen were paid by Sri Chandan Kakote. So this witness also admitted the fact that the employment was under the contractor. And side by side, your lordship can just keep over for the time being this part and come to page number 28, Annexure 7.
28.
Yes, 28, Annexure 7, which is a letter issued by the labor inspector. And there also, she mentions that the workmen involved in the case are contract laborers under the contractor. In enclosing here with 2 copies of comments, one from the principal employer so-and-so and the other from their contractor so-and-so, I have the honor to inform you that the complainant Biju Banika appears to be a worker under the Contract Labor Regulation Act 1970, for which their views stated in the same letter above appears to be appropriate as per laid down provisions of the State Act. As such, it appears that there is no scope to intervene in this case under the Industrial Dispute Act so-and-so for protection of the service of the complainant contract worker. So this is also a reference to the position that their employment was under a contractor, and which is also admitted by the workman's witness. Now, paragraph 9.
Yes.
Now, paragraph 9, at page 59, the workman witness number 2, Sahadev Burman, is one of the workmen in this case. In his deposition, he stated that he is the senior most workers amongst the applicants. He had joined in 2006 as worker in production of so-and-so. Although applicant workers were engaged with the production activities under direct and control and supervision of permanent employees, named Subhash Muduli, senior supervisors, Sri Noboreka Kishodas, so and so, so and so. All are supervisors, and Sri Niraj Sekia, Malin Das and Pavilan Das are the line leader. They keep their attendance in a daily time card, of which first page is printed as Chandan Kakoti, Amingaon, Guwahati. Card number, name of workers, number of days, attendance, and signature of the manager, etc. The above named supervisors and line leaders direct them to attend the work in various places of the factory, which were selected by and they supervise the work regularly. There is no independent contractor by name so and so under management of so and so as claimed. Chandan Kakoti has not issued any appointment letter, employment card to them under Contract Labor Regulation and Abolition Act 1970. Even said Chandan Kakoti did not direct or supervise them in their work. He did not tender any resignation in writing or verbal as alleged by the management in their written statement. So far his knowledge goes, no one of the applicants, workmen, had resigned from service on 17/8/2013. He was absent for few days in his duties for treatment of cancer at Sankardev Netralaya, Beltala as insured person. Still, he is not fully recovered. On 19/8/2013, the management debarred entry of some selective workmen into the factory without issuing notices intimating reason. The applicant workmen were among such workers. On that day, rumors spread from the management side that the workmen were debarred entry due to their involvement with trade union activities, and if they gave up such activities and submit an undertaking, entry into factory premises would be allowed. On 28/2013, as many as 23 had filed a complaint petition before Assistant Labor Commissioner to get reinstatement in their service. Later on, it is learned that their complaint petition was sent to the management, and the management was also replied with a sidelining comment without attending on the allegation that their services were terminated for the trade union activity. The Factories Act, Payment of Wages Act, and the Contract Labor Regulation and Abolition Act have mandated to maintain some records of employed persons in prescribed manner and preserve them. The terminated workmen are not in any gainful employment, though tried hard. All are poor wage earner, and due to non-engagement in any gainful employment, their livelihood are going through a lot of suffering. In cross-examination, this witness has stated that his evidence in chief is prepared by Sri Basanta Kumar Kalita as per his instruction. He has submitted some documents, that is exhibits 1 to 6, but except exhibit 6, all other documents are photocopy. He knows witness Sri Ghanasham Vaishya, an employee and the management. He knows Chandan Kakoti, the contractor. On the basis of the daily time card issued by Mr. Chandan Kakoti, they worked. His daily wages were paid after conclusion of month in cash. He has not submitted any document to show that they were engaged by the management of Messrs. Imami Limited. He does not know Mr. Bijuboneko. He availed the benefits of ESI and PF. On Swenson, he was not in duty. Though he is a member of the union, he has not submitted any document to that effect. Witness number 3, another applicant workman has deposed almost on the same line as deposed by WW2. In cross-examination, he has stated that he used to work as per time card issued by Chandan Kakoti. Chandan Kakoti is the contractor. He availed the benefit of PF and ESI. He has also withdrawn the amount of PF. His evidence is only confined for him. He does not know about the other workmen. He does not know Mr. Biju Bonikyo. He has admitted that he was engaged by the labor contractor, Mr. Kakoti. But he has denied the suggestion of the management that he has filed this case against the management on false allegation. Denying the case of the workman, the management examined so-and-so assistant manager of Imami. In his deposition, he has stated that Imami is a reputed company engaged in manufacturing of Ayurvedic medicines and herbal cosmetics under so-and-so. The registered office is at so-and-so. In Amingaon, there is 171 numbers of workmen who are working on regular basis. Besides the regular workmen, they also used to engage contractor for various activities as per registration certificate dated 21/1/2004, issued by the government of Assam. The laborers in the petition claimed as workmen of Imami are not the workmen of the company, since the state laborers were not engaged by the management, and they were actually engaged by one of the contractor, Mr. Chandan Kakoti, who is a licensed labor contractor. By virtue of an agreement entered with the state contractor for packaging various products. The Lordship may kindly note this aspect that the engagement was for packaging various products. Now, if someone is to be involved in the activity of this kind, naturally his involvement will be in the assembly, inside the factory, and inside the factory there will be someone to direct or supervise them. That is to say, where from the product line has to be maintained or the product chain has to be completed. The Government of Assam Office of the Assistant Labour Commissioner Guwahati issued license number so and so to the said contractor for doing the work of packing, unloading and material transportation in the establishment of the management. The said license is valid up to 22/12/2014. On the strength of said license and the agreement, the contractor engages laborers as per the production plan and requirement. Since the said workmen were engaged by the contractor, therefore the provisions of section 2A1 of the Industrial Disputes Act does not attract in the present case. The management never engaged any of the workmen as claimed. The status of the workmen is daily wages labor, and therefore the said daily wages labor cannot be the workmen of the management under the Industrial Disputes Act 47. It appears that the contractor engaged by the said laborers as per his requirement depending upon pending work and production activity. The work carried out by the state laborers under the said contractor is seasonal and not permanent. There is no connection with the management that the workmen, since they were engaged by the contractor.
Why is it seasonal, not permanent?
It's dependent on the production, Milord.
Is
Because
it
the
a seasonal,
production-
is it a seasonal production?
Because there are various kinds
This is
of
not a
products.
fruit product
No, there
or
are
tea.
they produce cosmetic products, herbal products. So
Cosmetic, which month is there where cosmetics are less in use?
No, Milord, that is a matter to
Yes.
be decided by the management.
No, I'm just asking you,
Yes. So
cosmetics, something like cosmetic, is there any particular lean period for cosmetics?
maybe because they are the name
Maybe
of the
from your
product.
personal experience, are you telling? Maybe.
So the kind
may-
of products
You
that
may
they
be in
have,
trouble.
no, if your lordship will kindly see they have made the kind of product, name the kind of products, cosmetics and herbal medicine.
Yes.
They produce herbal medicines, Ayurvedic medicines and herbal cosmetics.
This kind of objections you have been taken just for the sake of it. Seasonal, permanent, because in some cases, it's been said.
No,
so-
even if it is
For
not
products of this nature, there is no question, concept of seasonal or permanent.
even if it is not seasonal or even if it is not temporary, the question would still arise whether they were under direct employment of us.
That question, have we made any comments? We have not made any comments.
So that
That we'll examine definitely.
yes. Now
Whether these
Now
15
see-
numbers of persons who have termed themselves to be workmen were directly under you or
Yes.
were they
Or-
under the contract,
under the
contractor, under the Chandan Kakoti?
Chandan
That
Kakoti,
that-
yes. Now,
Yes.
why I am saying this, the question of seasonal, maybe because of the fact that they are producing Ayurvedic medicines and herbal cosmetics. Now, among the Ayurvedic medicine, your lordship may know from personal experience that the Zandu, because their brand name are Himani, Imami, and Zandu. They also produce Chyawanprash and the kind of thing. So these kind of things do not sell in summers mostly. It goes off shelves during the winter. The
Is
Chyawan-
it?
Yes, my lord, that is the experience. Because I am not saying the cosmetics, but the Chyawanprash and other Ayurvedic products, these are most of the times, my lord, we see that going off shelves during the winter most. So maybe that is the reason they have mentioned it that this is seasonal activity. Anyway,
You don't have a backache in the summers.
my lord,
You don't have backaches in summers.
no, I am only on the Ayurvedic medicine product. I'm not on the cosmetics and all. Because
Chyawanprash, you don't need energy in summers.
Some of the products, my lord, mostly they sell in the winter, not in the
Okay.
summer.
Okay, proceed. Okay.
That status of the payment and wages are to be paid by the workman by the contractor. Therefore, there exists no relationship between the employee between such workmen and the management. The management is not the employer in respect of laborers, workmen in the instant case. Sri Biju Banikka, a daily wage laborer engaged by the labor contractor, filed a petition number petition dated so and so before the Assistant Labor Commissioner, alleging termination of his engagement. In pursuance to the said petition, the labor inspector issued notice dated so and so to the management, asking management to submit written statement. Management submitted written statement before the commissioner. The authority-wide communication dated 15/2/2013 intimated the parties that there is no scope for intervention in the case as complained by so and so. 15/2/23. This 15/2/2013 letter I have shown to your lordship, my lord, by which It was at page 28. Intimated that the parties that there is no scope for intervention in the case as complained by so-and-so under the Act for Protection of the Service of the Complainant Contract Labor. There is no control of the management over such labor. As per the required work, the contractor is at his own discretion choose and engage laborers of his choice. Since the said laborers were not engaged by the management, therefore the said laborers do not have any right for any entry into the factory in absence of permission granted by the contractor. And as such, the question of issuance of notice by the management to the said laborers does not arise prior to debarring their entry into the factory. Since the workmen were not the employee of the management, therefore they cannot have any right for demonstration or any dharna in the factory gate. The workmen, namely so-and-so, 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 are still working under the contractor. As per the ECIS and ECPF, as per law, the ECIS and ECPF are required to be paid by the contractor to the laborers engaged by him. As such, it appears that such payment was made by the contractor. The relationship of employer and employee within the workman and management does not exist.
I'm just coming back. That communication is 15.2 or 15.7?
Page 28, your lordship. Come back. That is
I think it's 15.7,
15.7.
not 15.2.
Maybe it's a typographical error in the.
No, that is
Yes,
okay.
15.7,
It's not 15.2.
not 15.2, 15.7.
No, it can't be, my lord. The dispute was raised on 26/8/2013. So this
So it is
15/7, that is in August, the dispute was raised. So cannot be, this
No, it was-
15/7 is something different, my lord.
No,
Lordship, my
15,
page 29 is letter of the labor authority.
No, see, the subject forwarding a petition in the service matter of Biju Bonikko.
yes.
It is in the context of the this present, maybe there are some communications going on.
But it is not, it can't be 15/2.
No, it is 15.7.
It is
The
15.7.
date is 15.7. See the page 28. It's a
28 bottom.
typographical error. maybe.
15.7. It seems to be a typographical error in the judgment.
Now, there are in two places the date is very clearly written. One in the memo and one in the signature.
Yes, 15.7.
15.7. Mr. Chakraborty at page 28.
28.
If the lordship takes up 29, page number 29, then the complaint is dated 28/2013. Enclosed, please find herewith the Xerox copy of complaint petition dated 28/13 submitted before the ALC against you by so and 13 others in connection with the subject matter already mentioned
No,
above.
this is by one Azharuddin Ahmed.
Yes.
This was by one Biju Bonikko.
And your lordship at page
I'll
25,
come back to your lordship.
at page 25, your lordship will find the handwritten complaint.
20?
Page 25, that is dated 29th of May 2013. Page 25.
By Biju Bonikko.
Yes.
Okay.
So it is in that context that the 15.7 letter was issued.
Yes.
And this 15.7 finds a mention here. I mean, there is a typographical error. It makes a mention of 15.2. But this is in connection with that. I think, Lord, I'm clear on this. As per the, I was reading down below, as per the law, the ESIS and ECPF are required to be paid by the contractor to the laborers engaged by him. As such, it appears that such payment was made by the contractor. The relationship of employer and employee between the workman and the management does not exist in the present case. The workmen were engaged by the contractor and not by the management. Therefore, the provisions of Section 25F of the Industrial Dispute Act does not attract in the present case. The workman cannot raise the claim of regularization since no relationship of employer and employee exists in case of daily wage laborers, and that too those whom were engaged by the contractor. So paragraph 12, let us discuss whether the workmen have proved their case on preponderance of probability. According to Sri Ghanshyam Vaishya, the terminated workmen were regularly attended in the production manufacturing work of factory as operator, raw material feeder, line operator, workers, etc. under direct supervision and control of the permanent employees of Messrs. Simami. They were terminated for formation of trade union. The management was not happy at all in the event of formation of trade union. Thereafter, the management debarred entering into the factory for some selective workmen with effect from 19/8/2013. Sri Sahadev Burman in his deposition has stated that the workers were engaged in the production activities under direction, control, and supervision of permanent employees named so and so, so and so. They keep their attendance in the daily time card, of which the face page is printed as Chandan Kakoti, Kamengao, Guwahati. There is no independent contractor by name of so-and-so under the management, and so-and-so has not issued any employment letter or employment card to them under Contract Labor Regulation and Abolition Act 70. The Sri Gulab Boisha has also stated that all the applicants
What
were-
is this, these two lines we are not being able to understand? They keep seventh line from the bottom.
they keep their attendance in their daily time card, of which
The
This-
face page is printed as Chandan Kakoti.
now-
Okay. The next line, what is it? There
there is no independent contractor by name Chandan Kakoti. They wanted to say that although perhaps this is the message they want to convey, that perhaps that although the time card was issued in the name of Chandan Kakoti, but in fact there is none like them, or there is no agreement between Chandan Kakoti or the principal employer.
Was Chandan Kakoti produced in the labor court?
Chandan Kakoti was not even a party in the proceeding.
No, no. Was he produced as a witness?
No, Chandan Kakoti
You did
was
not produce him.
no. No, Chandan Kakoti. yes.
Management examined.
Management
Of course,
examined.
Management will examine.
Management examined him as MW2.
He'll be your star witness in
Yes,
fact.
he is MW2. Next page, your lordship will find his name. So the time cards were issued to him, and he gave the time cards to selected workers, whoever he wanted to bring.
Let us see the version of Chandan.
Next page,
this
third
guy-
paragraph. Paragraph
Discussion.
13, subparagraph 2.
65.
According to MW2,
Yes.
well, may I just complete the other two witnesses? Only two paragraphs.
Yes, yes.
The first witness, Deepak Sharma, paragraph 13.
Hmm.
Paragraph 13, next page.
Yes.
According to management witness number Sri Deepak Sharma, the laborers in the petition claimed as workmen of Imami are not the workmen of the company, since the said laborers were never engaged by the management and were actually engaged by one of the contractors, Chandan Kakoti, who is a licensed labor contractor by virtue of an agreement entered with the state contract for packaging various products. The status of the workmen is daily wage laborers, and therefore the state daily laborers cannot be the workmen of the management under the Industrial Disputes Act 1947. According to MW2, Chandan Kakoti, the contractor of the Imami Limited, the workmen were worked under him on the basis of the time card issued by him. The status of the workmen like daily wage laborers. The laborers are engaged as per requirement depending upon the pending work and production activities. There is no role of management as to whom he engages for work, and the management does not have any control over such laborers. The management is not the employer in respect of the laborers workmen. I have gone through the agreement, that is Exhibit C. As per agreement, management appointed Sri Chandan Kakoti as non-exclusive contractor on job work basis to carry out the activities of various products from bulk to retail pack. Exhibit D shows that the license issued to the contractor Chandan Kakoti for doing the work of packing, unloading, and material transportation in the establishment of Imami Limited, but the agreement was not for supply of laborers. The management has failed to show that agreement was made for supply of labor. That is the exception that the labor court has drawn. Admittedly, no appointment letter was issued by the management, but all the applicants' workmen were working under the supervision and control of supervisors and line leaders, who are the permanent employees of the management. WW2 and 3 in their evidence have specifically mentioned the name of the permanent employees of the factory under whose supervision and control they worked. The management has failed to rebut the evidence of workmen witnesses. Services were provided to the management but not to the contractor. Mere writing the name of the contractor on the front page of the wage slip does not prove that the applicants or labor contractors were right to regulate employment is with the permanent employees of the management. That apart, it is found
Just
that
a minute, just a minute. Mayor writing the name of contractor.
It should be contractor.
Contractor.
In the front page of the wage slip.
Does not prove, how is the deposition of Chandan obliterated?
No, it is obliterated by this
No,
analogy
this
that-
observation
This observation,
intends to as if nullify Chandan's
Yes,
deposition.
yes.
How is it done?
And,
What is
and
the basis?
that, my lord, that is the case.
Where is the cross of Chandan? Any discussion on the
That is
cross?
indicated next paragraph. Next paragraph.
Yes.
It is not Chandan first, it is the MW one, but the Chandan's
MW1
cross,
is Deepak.
yes, Deepak Sharma, but Chandan's cross is not highlighted here. The Dwar Kotra record has been accepted. My lord, the originals are here.
Just a minute. There is no cross as such. It is a fact that I did not issue employment cards to the workmen. I have not issued wage slips to the workmen as per form number 19. I have complied the statutory requirements as regards license. It is not a fact that due to joining in the trade union meeting, the management restrained the workmen from entering into the factory.
Yes, that's it.
Just a minute. Okay.
So mere writing the name of the contractor on the front page of the wage slip does not prove that the applicants or the labor contractor were right to regulate employment is the permanent employees of the management. That apart, it is found that the contractor is not an independent contractor. This finding is also, my lord, in my respectful submission without any material. That apart, it is found that the contractor, therefore, contract is found to be sham and camouflage. Now, this is the finding which we have pleaded in our case, that this has become an issue before the tribunal, although before the labor court, although she did not frame any issue on the point. He has determined that the contract is sham and camouflage. Thus, it is
Are you
about
contending that the validity or legality of the contract was not even the issue raised?
not here, not even an issue.
That was not the issue for determination,
No.
whether there was a valid contract or not.
Yes. And that is our specific pleaded case, my lord, in paragraph 12. Paragraph 12, page 10. that the petitioner begs to state that no issues were framed by the learned labor court regarding the guideline genuineness of the contract between the management and the contractor, as there was no pleading and evidence from the side of the respondents before the labor court. Yet the learned labor court, going beyond the issues framed and without there being any pleading evidence, has held that the contract between the management and the contractor is a sham one. These findings are entirely perverse and contrary to the records, and as such, they are liable to it. This is our specific pleading in paragraph 12. Thus, it is abundantly clear that the management had economic control on the work of the workman, and the real employer is the management, not the contractor. And this finding is also in disregard to the admission by the workmen's witnesses that they were under the contractor. I have also perused the cross-examination of MW1 at the hands of the workman. MW1 in cross-examination has stated that he does not know about issuance of appointment letter under the Contract Labor Act by the contractor. He has further stated that he does not know who supervised the works of the contractor. From the time card issued by the manager of the company, it is well established that the workmen applicant are not the contract labor, but they are workmen of the management. This is another point. The real reason for not allowing the workmen to enter into the factory was the annoyance felt by the management when the workmen formed trade union. The act of the management is nothing but victimization and unfair labor practice. Then, well, the definition of workman is extracted. The Lordship can skip over and come to page 68. I'm starting from issue number 2 at page 67. The management in the written statement has pleaded that the labor contractor is a necessary party and the present proceeding is bad for non-joinder of labor contractor as a party. The instant proceeding is filed under section 2A 10 amended ID Act and not under Contract Labor Regulation and Abolition Act. In view of my decision arrived at issue number 1, that the workmen are not contract laborers engaged by the labor contractor. Therefore, I am of the considered opinion that the labor contractor is not a necessary party. Because our objection was that your Lordship will read the section 2A, where any employer discharges, dismisses, retrenches. There has to be an employer-employee relationship. That is the precondition of section 2A. And regardless of it, my lord, my submission, as I would make, that it speaks of an individual workman. It does not speak of a situation where a group of employees can espouse the cause, or a group of employees can join in a single petition before the court. That submission I will still make, my lord. That is one of the grounds urged in the writ. In non-gender of necessary party. Reverting back to the evidence on record, issue number 3, it is found that the workmen were not allowed to enter into the factory with effect from so-and-so. Their services were discontinued since then in violation of section 25 of Industrial Dispute Act. Now, it is since the learned labor court perceives that there is a violation of section 25A, therefore, my lord, the order for compensation. The termination of service of the workmen is to be treated as retrenchment as per definition of section 200 of Industrial Disputes Act. The workmen have proved that they worked for 240 days. The management has not disputed that the workmen applicants had not worked for 240 days in the preceding year from the date of their termination. Undisputedly, no notice or 1 month's wages in lieu of notice and retrenchment compensation was paid to the workmen. This makes their termination illegal and void for contravention of the provision of 25F of the Industrial Dispute Act. Therefore, the workmen are entitled to get relief, but question arises what relief can be granted. The workmen have paid for reinstatement with full back wages. On the scrutiny of the facts of the case, it is found that the applicants are workmen, not the permanent employees, and they were not appointed by following some procedure. The workmen have not submitted appointment letter. They are daily rated workers. Now, if they are daily, now this is contradictory, my lord. If you say that 25F is violated because I was an employee of the management and all, then why not reinstatement? And at the same time, the finding also comes that they are daily rated worker. The last line. they are daily rated workers. Now, if they are daily rated workers, which was our contention before the tribunal, before the labor court, then my lord, the findings has to go hand in hand with the other finding. In catena of decisions in the recent times, the Honorable Supreme Court has clearly laid down that an order of retrenchment passed in violation of Section 25A, although may be set aside, but an award of reinstatement should not, however, automatically pass. The award of reinstatement with full back wages in a case where the workman has completed 240 days of work in a year preceding the date of termination, particularly daily wages, has not been found to be proper by this Honorable Court, and instead compensation has been awarded. In view of the decision of the Honorable Supreme Court, I am of the opinion that it will not be justified to pass order of reinstatement, and instead the workman should be given monetary compensation which will meet the ends of justice. Then paragraph 18, so-and-so having its registered office at so-and-so is a renowned company which has 171 numbers of workmen who are working on regular basis, considering the financial position of the company and balancing the convenience and inconvenience of the parties. An amount of rupees 75,000 is granted to each of the applicants as compensation, which is, in my view, would meet the ends of justice. So this is the award. Now, my first submission would be on Section 2A.
Yes.
Now, if I may read the Section 2A once again, my lord. Dismissal, etc., of an individual workman to be deemed to be an industrial dispute, where an employer discharges, dismisses, retrenches, or otherwise terminates the services of an individual workman.
Yes.
Any dispute or difference between that workman and his employer connected with or arising out of such discharge, dismissal, retrenchment, or termination shall be deemed to be an industrial dispute, notwithstanding that no other workman nor any union of workmen is a party to the dispute. Notwithstanding anything contained in Section 10, such workman, any such workman, as is specified in subsection 1, may make an application direct to the labor court or tribunal for adjudication of the dispute referred to therein after the expiry of 45 days from the date he has made the application to the conciliation officer of the appropriate government for conciliation of the dispute, and in respect of such application, the labor court or tribunal shall have the powers and jurisdiction to adjudicate upon the dispute as if it were a dispute referred to it by the appropriate government in accordance with the provisions of this Act. And all the provisions of this Act shall apply in relation to such adjudication as they apply in relation to an industrial dispute referred to it by the appropriate government. Now, here your lordship will see only 3 applicants, 3 of the workmen, 3 of the respondents. One Biju Bonikko, one is Ahmed. Page 28.
One is Biju Bonik, one is Azharuddin.
Yeah, Azharuddin. One is Biju Bonikka and one is Azharuddin. They filed application before the labor officer.
Biju Bonikko page?
Biju Bonikko is at page 25. Page 25, annexure 4.
Okay, we'll come back
Yes.
in 5 minutes. You are trying to elaborate this point by saying that the disputes, individual disputes which were also raised was only by not all but few.
Yes.
In that context, you are trying to
Yes.
harp on 2A.
Yes.
We understood in a different context. We thought maybe individual applications are there, but those were clubbed together to form one reference.
No.
That is not the case. There were no cause was espoused at all.
No.
Before the conciliation officer.
No.
Individually by the workmen.
Yes.
Or maybe by a group of workmen in one petition.
Yes.
Even that would have
in
been
one petition, my lord, had it been in one petition, everyone is coming, and the subsequent
So in
requirements.
the reference, the names of those persons who have not even raised the issue of their retrenchment.
Yes.
And it was not espoused by the union in representative capacity.
Yes.
So under that context, you are trying to develop 2A. Okay.
Yes.
In fact, all the workmen combinedly approached the labor office.
Where is the document?
Yes, I'll show it from their own writ petition.
Okay.
I do not know why he is not referring.
Okay.
Any Vishwas.
Just a minute. Respondent number 5.
Yes, respondent number 5. Kalyani Vishwas, and respondent number 13, Jalaluddin Ahmed.
Or 13.
They did not raise any dispute. Yes. এটা তো 29 না যাবে তো। এটাই আছে।
They did not file any application.
No, no, they also did not raise any dispute. I mean, yes, they did not file
File
any
an
application.
application.
Yes. Now, Annexure 1, your lordship will see at page 18,
Yes, please.
page 14. কাটা গেছে ঠিক, না, ঠিক, 17. 17, Annexure 1 is the license in the name of Chandan Kakoti, and it was exhibited at Exhibit 4. Your lordship has found the reference in the judgment.
License.
Yes. And next, Annexure 2, page 20 is the agreement, which was also
This is
exhibited.
exhibit.
License was exhibited at Exhibit 4. Exhibit 4, na? Exhibit 4. I'll just confirm it again. Check and confirm taken.
Yes.
No, exhibit, yes, Exhibit D is the license and Exhibit C is the agreement.
Exhibit D.
Yes, license was exhibited, license is Annexure 1. It was exhibited as Exhibit D. And Annexure 2 is the agreement which was exhibited at Exhibit C.
Where is the agreement? Annexure 2.
Annexure 2, page 20.
Just a minute, please. Page 20.
It was exhibited as Exhibit C.
20 is the agreement.
20 is the agreement.
Exhibit C. Agreement.
It was exhibited as Exhibit C.
Agreement dated.
It is 3rd of May 2013. Sorry. Date may differ. So the date is not mentioned, Miller. Date may differ.
Has any date been mentioned
No.
in the deposition?
In the deposition as it is extracted, Miller, no date is mentioned.
No, while deposing that we had entered into an agreement on such and such date.
The deposition has been extracted at paragraph 13. There is no mention of any date.
Okay. This is with Chandan.
Chandan, this is with Chandan.
Okay.
I can check it. Agreement is not taken.
So far as your
No.
first,
Yeah, first time coming.
no,
on-
first you had pointed out R5 and R13 that they did not make any
no,
application.
They did not make.
Other than those two, the RS13 has filed application.
That was a subsequent application, subsequent to filing of Biju Boniko.
But before raising the dispute in
Yes.
the reference court.
Before the coming to labor court, they filed an application. Now Biju Boniko filed an application. There was a determination by the labor officer that it cannot be gone into, and thereafter Biju Boniko did not pursue the matter any further. Subsequently, this application comes, Azaruddin Ahmed. This application comes, and in this application, he says that me and the below mentioned people, we have been terminated, so intervene and give us protection.
Below mentioned did not have the names of Kalyani and Jalal.
No. Page 32, your lordship will kindly see. 31A is the typed copy, handwritten copy, 31A and 32. Page 32 is the below mentioned people. There, the name of Kalyani and this Jalaluddin do not find mention.
But there were others.
There were other.
But why in the reference 15 workmen were there?
That is somebody they also included in the at the time of filing the application. These two persons were included in the lease.
No, that is a different aspect. This page 31 has got 23 numbers of workmen.
Yes, but there were only 15.
15.
Only 15.
8 out of this were not included in the reference.
No. Practically, that was only 13. Only 10 were left out. Additionally, they put 2 more. 2 who were not in the
List.
So 13 plus 2 makes it 15. Out of this application, 13 people went to labor court.
Okay.
Now, as I was reading the section 2A, if your lordship will kindly consider the wordings in section 2A and section 2A2. It speaks about workmen in singular number.
Yes, we've seen that.
So therefore, it does not conceive of a situation where a joint application can be made or a joint application can be, a joint decision can be espoused before the labor court by circumventing the provision of section 10. So that is the reason, my lord. Our submission is that on these grounds, the application under 2A could not have been entertained. On 2A1 and 2A2, both speak of a situation where it is by one individual, and the language is clear that notwithstanding anything contained in section 10, any such workman as is specified in subsection 1 may make an application direct to the labor court or tribunal for adjudication of dispute referred to herein after the expiry of 45 days from the date he has made the application to the conciliation officer. So on this premise, the first submission is that this application was not maintainable for this reason. The second is that the issue. The second is about the issue, my lord, that your lordship has seen. That no issue was framed with regard to the genuineness or otherwise of the agreement, nor was it a question gone into in the sense that neither of the parties laid any evidence. There was also no pleading by the workmen in the application file that this was a sham agreement or this was to be declared as such. Without framing any issue, my lord, this has been gone into. Your lordship will kindly see the application file before the management. That is at page 39. Sorry, That is at page 34. Page 34. The starts from page 35 after the array of parties. So paragraph 3 says that the complaint before ALC at Ulubari, Guwahati did not result an application under section 12 of the IT Act was placed, but refused to accept. And refused to accept, and in such situation, the matter of termination of service of some workmen at Messrs. Imami Limited was brought into notice of the Labour Commissioner at Gopinath Nagar so who directs the ALC Kamrup to do the needful on the matter, White communication number so dated 11/12/2013. But till date, the direction is not complied with. Hence, this application before your Honorable Court for end of justice. And the array, your Lordship will see 15 people at page 34. 34. 15 people, out of which only 13 had gone before the labor officer. And in the entire of the application, well, there is no whisper that the agreement is sham or the agreement is concocted, nothing like. Only thing is that they claim that they are of employees of permanent nature and therefore they should be protected under 25N.
Okay.
There was violation of 25N and they should be protected. That is the only case. So the tribunal had gone into an issue which actually was not even framed. And we specifically
Just a
took-
minute, just a minute. One minute. See, there can be a possible answer. We have not heard Mr. Chakraborty. Here in 35, there is there is not even a whisper with regard to any contract labor.
No.
So since that was not even their case, that there was involvement of Chandan Kakoti, that they were connected to the management through Chandan Kakoti, or maybe management would try to bring in the concept of some contract labor so that there is no such agreement. They have simply stated in paragraph 2 at page 35 that
On
all
19
so management debarred the entry of some selective workmen into the factory premise without prior notice. Workmen were engaged with regular nature of work since 2006. They demonstrated protest and therefore filed a complaint. So,
No.
and this element of contract labor is a part of your defense, which you have brought in your written statement.
Yes.
That was not even in the contemplation of the initial disputes which they have tried to raise. So obviously it will not be one of the issues.
No, but issues were framed after receipt of our written statement only. The tribunal, I mean, the labor court framed the issues only after the written statement was filed, because in the issues that the tribunal has discussed.
No,
at
the
paragraph
issue,
4,
the reference would, oh, here there was no reference.
There was no
Okay,
reference.
Okay.
there was no
Oh,
reference.
you're correct. In a section 10 application, had it been section 10,
Then,
then the issue would have been framed by the
Yes.
appropriate government,
yes,
which is not been done in the instant case.
Yes.
It's a two-way application.
yes.
So after hearing of the parties in the initial stage of written statement, issues as to be framed, then you adduce evidence.
Yes, and the tribunal, I mean, the labor court framed the issues at paragraph 4, page 56, whether the workmen number 1 to 15 are contract laborer, because this indicates that the tribunal was alive to the defense taken by the management, that there was an element of contract laborer. So, in that view of the matter, it was.
No, you may be correct, because unlike a 10 reference, where issues are already
Determined by the,
framed by
framed by
the
the government.
appropriate government for determination.
yes,
Here, issues are framed by the court as if it's a normal civil
not
court.
normal civil code. Now, if
Oh.
your lordship will kindly see our WS at page 41.
Yes. 4-1.
Yes, 4-1 page, paragraph 3. Paragraph 3.
Yes.
Firstly, the aforesaid contract laborers were engaged by Mr. Chandan Kakoti, who is the licensed labor contractor. The management at the said contractor entered into an agreement for packaging various products. The Government of Assam, Office of the Assistant Labor Commissioner cum Licensing Officer, Ulubari, issued license number so-and-so, dated so-and-so under the provisions of Section 12(1) of the Contract Labor Regulation and Abolition Act to the said contractor on payment of requisite fee for doing the work of packing, unloading, and material transportation in the establishment of the management. The said license is renewed and valid up to so-and-so. On the strength of the said license and the agreement, the said contractor engages laborers as per the production requirement and plan. Since the said laborers were engaged by the contractor, therefore, the provisions of Section 2A1 Industrial Disputes Act, briefly the Act herein after, does not attract in the present case. As such, the case is not maintainable. Secondly, the laborers as claimed is workmen in the petition are not the workmen of the management, since the said laborers were never engaged by the management. Therefore, no relation of employer-employee or employers and workmen exists between the management and the laborers in the instant case. The management is not the employer in respect of the laborers workmen in the instant case. Therefore, the dispute raised in the instant case is not an industrial dispute under the meaning of Section 2K of the Act. In that view of the matter, the disputes raised by the laborers workmen cannot be adjudicated by the Honorable Court, and therefore, in the instant case, is liable to be dismissed as the threshold. And thirdly, the case is not maintainable for non-joinder of necessary party, because Chandan Kakoti was also not made a party, so that is the plea. Now, the averments were denied, and as regards the complaint filed in paragraph 7, the reference of Biju Boniko's complaint is made, page 44. It is stated that once Sri Biju Boniko, a daily wage laborer engaged by the labor contractor, filed petition dated so-and-so before the Assistant Labor Commissioner, alleging termination of his engagement. In pursuance to the said petition, the labor inspector issued notice dated so-and-so to the management, asking the management to submit written statement. The management submitted written statement so-and-so before the said authority, stating that such daily wage labor is engaged by the contractor and the supply of laborers is solely depends upon the production plan and schedule, and there is no scope for permanent absorption of such labor. In fact, the contractor also, while later dated 7/6/2013, intimated the said authority that the requirement of labor is fluctuating. Sometimes the requirement of labor is more and sometimes the requirement is less, and keeping in view the nature of work which depends upon the production plan, no daily wage labor can be retained permanently. The said authority, via communication dated 15/7/2013, intimated the parties that there is no scope for intervention in the case as complained by Sri Biju Boniko under the Act for protection of his service of the complainant contract labor. Now, these communications were thereafter enclosed. And in paragraph 5, it was specifically pleaded that workmen are never engaged by the management directly. Management does not have any relation with such workmen and they were unknown to the management. It is for the contractor as to whom the contractor engaged for the work. There is no control of management over such labor. Nature of work against which the contractor engages laborers is not regular but seasonal in nature. As per the required work, the contractor is at his own discretion to choose and engage laborers of his choice. Since the said laborers were not engaged by the management, therefore, the said laborers do not have any right for entry into the factory in absence of permission granted by the contractor, and as such, question of issuance of notice by the management to the said labor does not arise prior to debarring their entry into factory. Since the workmen are not employee of the management, therefore they cannot have any right for demonstration of any dharna in respect in the factory gate, and such dharna is illegal and unauthorized. And as regards PF Millard in paragraph 9, page 46, the
Yes.
second paragraph, the statements made in the paragraph 5 of the petition is not admitted and denied by the deponent. Payment of ESIS and ECPF are the requirement as per law to be paid by the contractor to the laborers engaged by him, and as such, it appears that such payments were made by the contractor. It is denied that applicability of PF and ESI can be the basis for showing that the nature of workman is permanent in nature. It is stated that PF and ESI is since applicable to the laborers engaged by the contractor, therefore the same was made applicable to the aforesaid labor. So from the facts that was placed before the labor court, Millard, these also appear that it was at the control of the contractor who he will deploy for work, because Biju Bonikko was the first person to come before the labor officer, raising a dispute that he was not allowed to work or he was terminated. But for whatever reason, he abandoned his course. That's a different story. But to come to a conclusion that this document is a sham, or there were in fact permanent nature of employment, it was supervised inside the factory, whoever will work, Millard, that there has to be some supervision by the employees of management, because the contractor would not be knowing where to deploy the particular person for particular work, because there was a range of activities which was required by the contractor in respect of which he was to supply the workforce. And in paragraph 12, page 47, this has been specifically stated that since the said laborers were never engaged by the management, therefore the question of their termination does not arise. If the said laborers are not engaged by the contractor on a particular occasion, such non-engagement by the contractor cannot be faulted with the management. As such, the provisions of section 2A does not attract in the present case. It is humbly submitted that in various decisions of the Honorable Supreme Court of India has already decided that such laborers cannot raise the claim of regularization, since no relationship of employee and employer exists.
Where is the, in your written statement, we have just had a cursory glance. Where is your plea regarding the maintainability on the section 2A?
That is at page 41. Page 41, paragraph 3.
Not that has been argued. Not on the ground that it is a joint petition.
Yes, it's not on that we are asking only.
It is not pleaded. Their pleading is that
No,
since
we'll
they are
come back,
contract laborers,
we'll
so
come back
2A
to
is
that.
not.
That was not perhaps raised in the
No,
labor
It was
court.
not.
The contention that I have raised now, that is on an interpretation of section 2A. So that interpretation, I do not know whether it was argued or not argued, but the fact that 2A does not permit such an application, that was pleaded.
No.
So it is there.
Where?
Therefore, the paragraph 3, page 41,
Yes,
last 3 lines.
yes.
Therefore, the provisions of section 10(2)A Industrial Disputes Act herein does not attract in the present case, and the case is not maintainable.
No, on one premise. You cannot just read the last line. You have to read the preceding lines.
It was on the premise, yes. It was on the premise
Contract
that,
or contract labor.
it was on the premise that there was contract
No,
labor.
that we have understood. That
And-
here you may not be precluded from raising an issue with regard to a point of law. That can be made available, but I am just asking whether you had taken this point as a kind of a preliminary ground
No,
or any ground.
no, it was taken as a ground that because they were contract laborers.
That is a separate
Yes.
independent ground.
Yes,
That has
but-
been answered also.
Yes, but in the writ petition, we have specifically stated.
No, read, we are not on this court.
Yes.
We are on the stage
No,
of the labor court.
In the labor code, this was the only ground.
I think that was not pleaded.
No. No.
Okay, anything else?
And the other thing, about the issue I have already submitted, and regarding this compensation, Miller, the labor court has awarded a compensation of 75,000 each on the premise that they were employees of the management, and the relationship of employer-employee was there. This is the perceived premise on the basis of which the compensation has been awarded. Now, whether or not that is correct, that your lordship will kindly consider in the light of the submissions made. But this quantification of compensation at rupees 75,000 each, that is in my respectful submission is without any basis. It's yeah, just on the whims and fancy of the learned court that the amount has been quoted. Why it is 75? Why it is not 1 lakh? Why it is not 10,000? There is no basis. No reasoning has been given why 75,000 has been chosen. Now, on that count also, my lord, this is an unreasonable figure, unjustified by any reason. And the learned court has overlooked the fact that the admission of workmen's witnesses are there, that they are contract laborers. They worked under the contractor. Two witnesses were examined, and both of them had admitted this fact. Just for the purpose of recapitulating, my lord, if your lordship will kindly see the cross-examination part as extracted at page 59. Page 59, just above paragraph 9. 3 lines. He knows that so-and-so, he knows that 15 numbers of workmen of this case worked under the contractor. The name of the contractor is Chandan Kakoti, and these 15 workmen were paid by Sri Chandan Kakoti. This is a specific averment made by him. And the learned court has overlooked it. And similar in the similar line is also the evidence of the second witness. And at page 69, the court itself records that on scrutiny of the facts of the case, it is found that the applicant's workmen are not permanent employees.
Just a minute. By any chance, do you have the gazette notification, a gazette publication of this Act of 47?
Contract labor regulation.
No. Ideate. No, not now. Do you have, was opening gazette? Come?
By which this
No,
Who was
we
it?
are on a different context. I was just again reading 11A, the last part. I think they're just not connected with this case. Maybe it's also you may also have an interest. Just come to 11A.
11A.
A.
powers of labor court.
No,
Provided that.
That provided part, but please read the first part.
Where an industrial dispute relating to discharge or dismissal of a workman has been referred to a labor court, tribunal, national tribunal for adjudication, and in the course of adjudication proceeding, labor court, tribunal, or national tribunal, as the case may be, is satisfied that the order of discharge or dismissal was not justified. It may, by its award, set aside the order of discharge or dismissal and direct reinstatement of the workman on such terms and conditions, if any, as it think fit, or give such
Or give such
other
other
relief
relief to the workman,
including
including
the-
the award of any lesser punishment
in lieu
in lieu of discharge or dismissal as the circumstance of the case may require. Now come to the proviso.
provided that in any proceeding
Just,
under
just a minute, don't read so fast. The catch may be here, provided
that
that in any proceeding,
under this section,
no, in any proceeding, is there a comma here?
no.
No, in the gazette we want to see. If you put a comma, the second part, it becomes very easy for interpretation. Provided that in any proceeding, okay, under this section, the labor court or so-and-so is not required to take fresh evidence. That means to give a lesser penalty or any other kind of a relief, you need not have to take any other further evidence. This evidence is not required to be confined to the evidence of domestic inquiry also. It can be a full-fledged proceeding before the labor court. Labor court holds it to be dismissal, but to come to a finding whether a lesser penalty can be imposed, no other evidence is required. I think that should be the proper interpretation. If you put a comma after proceedings, then the entire thing becomes very reasonable and logical.
Provided that in any proceeding under this
No,
section.
in any proceeding.
After
Any
comma,
proceeding.
comma after
Wait,
any
wait.
proceeding.
Under this section, the labor court is not required to do any, take any further.
Because the comma is after labor.
Understood. That is why I wanted to have a look at the original. If you put a comma after proceeding, the interpretation becomes very logical.
More
If you
meaningful.
put a provided that in any proceeding, pause. Under this section, the labor code or tribunal, as the case may be, shall rely on the materials on record and shall not take any fresh evidence in relation to this matter. Fresh evidence is only with relation to giving a lesser penalty or any other relief in lieu of reinstatement.
My lord, if
Just
it
check
is
the,
confined to any proceeding, then my lord, perhaps this 11A is not exercisable by the labor court in a proceeding under 33. It is only in respect of reference.
yes,
So if in any
That-
proceeding would have included 33. That means a
Was it
dismissal or
dismissal?
discharge of a person or of a workman during pendency of a reference. In that case, 33(2)(b, for example, my lord, 33(2)(b, in that process, in 33(2)(b, labor code only examines whether there is a prima facie case or not. And then the matter.
no, if you come to 33 to be the entire direction will be on something else.
So if
If
This
you come to
11
this read, this 11A has to be read in the
With the reference
context of the first part, this proviso.
Yes.
section 10 reference note.
Yes.
So what are the wider scope I should do common aspect?
Now, if there is no reference, if it's a direct application under 2A, then
Under 2A, it is deemed to be a reference.
understood, but the word which has been the expression which has been used here is a reference referred to the labor code. 2A is not a reference to a labor code, but still 11A powers cannot be
My
held to
lord,
be not
this-
applicable.
My lord, 2A has come after amendment of 11A. 2A has come very recently. So after.
No, that is okay, but this, use of the expression for a matter which has been referred to the labor code cannot be confined to only at a reference under 10. It has to be extended to a 2A application.
2A also. Because 2A is
Just
very clear.
check the gazette again, the origin notification. Yes,
Now, another thing that I would like to highlight is that the labor court has given a finding that it's a retrenchment under section 200. That is the finding given here.
where is it?
Hmm?
Where is 200 involved?
Page 68, paragraph 16.
Is it a finding?
Yes, my lord. issue number 3.
Is to be treated, okay, right.
200. Now 200 speaks of retrenchment means the termination by the employer of the service of a workman for any reason whatsoever otherwise than a punishment inflicted by way of a disciplinary action, but does not include AB, your lordship can skip over. Double B, termination of the service of the workman as a result of non-renewal of the contract of employment between the employer and the workman concerned on its expiry, or of such contract being terminated under a stipulation in that behalf contained therein. If it is contractual in nature, my lord, then 200 doesn't come.
But
Now-
that contract has to be between the workman and the employer directly.
Yes, directly. Now here, despite giving this finding, my lord, the next page, the first paragraph, the learned court says that on the scrutiny of the facts of the case,
Yes.
it is found that the applicant's workmen are not permanent employees and they were not appointed by following some procedure. They are daily rated workers.
Yes.
And the previous page, your lordship will also find a finding that the workmen have proved that they work for 240 days. That is absolutely without any evidence. None of the parties have said as to for how many days uninterruptedly they work, except for saying that we work for 6 years, some work for 3 years, some work for 7 years. There is no specification given as to the duration of their employment, whether it was uninterrupted or
Mr. Chakraborty, you may not be correct. After Indian Iron, to overcome that 11A was incorporated. That was in the year 1971. 2A was in 1965.
No. 2A subsequent amendment, that is,
No, it is made subsections subsequently.
2A,
That is in 2000
earlier 2A, the language was persons, workmen who were dismissed, discharged, retrenched, they could have individually raised an industry.
Correct.
Now 2A has become different. That those who have been dismissed, discharged or retrenched, they have to they have to raise a dispute individually. And if that dispute is not referred within a particular period, then they can come.
There is some change in the procedure, but the
Yes.
power to give individual rights to the workmen
Was there earlier also?
was
No.
there in the amendment.
But earlier it had to be raised and a reference has to be made. Now to cut short the period of conciliation and reference, earlier what used to take place is a person is dismissed or retrenched. He raises an individual dispute. But for some reasons, for the delay of the authority, the matter is not referred for years together. Now to
No,
cut.
in fact, 2A was not there in the original act.
Was subsequent.
All disputes had to be raised through
Through a
the
union.
union.
Then
Then
2A
when it
came.
was found that in certain disputes which touches the individual rights, a dismissal, discharge, where the union perhaps for some reasons are not raising the dispute.
Either union or there are
Then 2A
institutes
powers
where-
are given to the individual.
establishments where there is no union.
Now, that 2A insertion was in 1965. And as you are correctly pointed out, later on in 2010 perhaps,
Yes.
the
2010.
procedure has been
Yes.
changed.
particularly subsection 2. 2A2.
Yes,
No,
yes.
what I meant at that time, that 2A doesn't mean that 2A, that is a reference under 2A. An individual dispute, not referred, but the workman approaches the labor court. And labor court will.
But
treat that
11A
as a
you
reference.
cannot give a restrictive meaning that it will only be confined to a section 10 reference.
Right.
Even for 2A application,
Yes,
you
it is
can,
applicable.
yes.
Perhaps not under 33(2).
33(2)B is a different concept.
So that's my submission, my lord. So this finding of 240 days, that they had worked for 240 days and uninterrupted work of 240 days, that is also beside the point. That is nobody's case, neither in the complaint nor in the WS, my lord. And there is also no evidence on that point.
Okay.
So therefore, my lord, my submission will be that this award has to be set aside.
Okay.
Huh? Okay. Paragraph.
Are we relying on any
And my
decisions?
lord, one decision in 2011, one STC page 635.
2011, One
one
SCC.
SCC, page 635. It is concerning the employer-employee relationship and the onus of proof. Particularly paragraphs 10 and 11. And also 12. Huh?
General Manager,
14
Bengal, Nagpur.
General Manager, Bengal Nagpur Cotton Mills, Bharat Lal. Paragraph 10, 11 and 12.
10,
11 and 12. The construction of the construction and meaning of control and supervision. হ্যাঁ? এটা তো ওখানে।
and that if the district adjudicator finds that the control. Yes, please read.
Paragraph 10.
Yes.
It is now well settled that if the industrial adjudicator finds that the contract between the principal employer and the contractor to be a sham, nominal, or merely a camouflage to deny employment benefits to the employee, and that there was in fact a direct employment, it can grant relief to the employee by holding that the workman is the direct employee of the principal employer. Two of the well-recognized tests to find out whether the contract laborers are the direct employees of the principal employer are whether the principal employer pays the salary instead of the contractor, and whether the principal employer controls and supervises the work of the employee. In this case, the industrial court answered both the questions in the affirmative, and as a consequence has held that the first respondent is a direct employee of the appellant. On a careful consideration, we are of the view that the industrial court committed a serious error in arriving at those findings. In regard to the first test as to who pays the salary, it placed the onus wrongly upon the appellant. It is for the employee to aver and prove that he was paid salary directly by the principal employer and not the contractor. The first respondent did not discharge this onus. Even in regard to the second test, the employee did not establish that he was working under the direct control and supervision of the principal employer. Industrial court misconstrued the meaning of the terms control and supervision and held that as the officers of the appellant were giving some instructions to the first respondent working as a guard, he was deemed to be working under the control and supervision of the appellant. The expression control and supervision in the context of contract labor was explained by this court in International Airport Authority versus so-and-so. And that is extracted. If the contract is for supply of labor, necessarily the labor supplied by the contractor will work under the directions, supervision, and control of the principal employer. But that would not make the worker a direct employee of the principal employer. If the salary is paid by a contractor, if the right to regulate the employment is with the contractor, the ultimate supervision and control lies with the contractor. So that is the case here also. And it is also admitted case of the workmen. In their evidence, they have stated that we worked under the contractor. And salary. Now, tribunal takes an exception that merely on the pay slip the name of the contractor is written. That will not make the contract make the employment under him.
Okay. Yes, anything else?
No matter. That's all.
Yes.
Uh,
We can have it at 2 o'clock.
My lord, first I'd like to draw your lordship's attention to the submission that section 2A doesn't apply. Lordship may come to the dispute raised by the group of workmen. Page number 30.
3-0.
3.
Yes.
This is the translated version. Humble submission is that we the undersigned are laborers working in Imami Amingaon. Out of the undersigned laborers, there are few laborers who have been working for 7 years, some of them working for 5 years and some of them for 3-4 years. But suddenly on 19th August, Monday, the undersigned laborers have not been allowed to join the duty. Reasons have not been intimated to us. The laborers of our company is going to form an union. We have a doubt preparing to form the union. We have been. Now, it contains a list of 23. This is how the dispute was raised. And since the matter involves dismissal or discharge of employees, so when this matter was not referred, after 45 days, this group of persons approached under 2. However, my lord, the issue of Bonico is something different. Lordship may have a look at the issue of Bonico. This has got nothing to do with the present reference and the adjudication. Lordship may come to page 24. That is dated 29/5/2013. Biju Bonico was suspended
Page?
24.
Yes.
Now he is saying, with due respect, I beg to state that I am a regular workman working under the contractors is so-and-so, Amingaon. On 13/5/23, suddenly I have been suspended from duty in this regard. No written notice has been served upon me. I did not commit any wrong in spite of having PF, PSI scheme. I have been suspended. Therefore, this is to inform you to take appropriate action for re. Now, my lord, this is a separate incident.
Yes.
So the issue of Biju Bonico has got nothing to do with this present adjudication. So referring to Biju Bonico,
Yes.
it can't be said that this Biju Bonico's reference was rejected. So this is that will also apply here.
Yes.
Now, my lord, this lordship has gone through the written statement of the management. This
Just a minute.
the written statement of the management.
Just
does
a
convey-
minute, just a minute. Bonico is not one of the respondents.
No, my lord. Bonico, issue of Bonico is totally different. He was suspended. Bonico, incident of Bonico happened in the month of May 2013. As per this letter, it is 13th May. And so far these persons are concerned, they were
He was
stopped.
not one of those workmen whose case was considered in the reference,
Yes,
in the case
yes.
by the labor court.
No, not labor court. That reference did not go at all.
No. In the award, which is the subject matter of challenge, Bonico was not a party.
No, my lord.
Okay.
Bonico is not a party because Bonico's incident took place on 13th of May 2013. So far these persons are concerned, their allegation is on 19th of August, they were stopped from entering the factory. So the cause of action for this adjudication arose on 19th of August. So on 20th of August, they raised this dispute jointly. And in that dispute, lordship may take that what was the stand of the management before the labor officer,
Okay.
page 33.
3-3.
Management's case is very simple, that they are the contractor's employee and this Chandan Bonico, third line, he supplies workers.
Chandan
who-
Kakoti.
Chandan Kakoti, he supplies worker to our factory on requirement basis. Now, if we take this stand, it is a stand of the management that the contractor is for supply of labor, not for any work.
Okay.
Now, what is the stand of the management in the written statement filed before the labor court? Lordship has gone through it. I would like to draw your lordship attention to it once again. Page 41.
4-1. Yes.
Just paragraph 3. Firstly, this is the preliminary objection with regard to maintainability of the case. Firstly, the aforesaid contract laborer were engaged. So management's projected case is that these persons are contract laborers, who is a licensed labor contractor. The management and the said contractor entered into an agreement for packaging various products. Now, in the labor office, their stand is that the contractor is a contractor for supply of labor. Here they are taking a stand that the contract is for packaging of various products. So, my lord, there is a huge difference. Packaging of products is a job contract, and supply of contract laborers is a different altogether. Now,
Let us see the contract.
my lord, I'll just for a moment, lordship, I'll come to that contract and other parts also. I'm just referring to this because of section 2A, objection with regard to maintainability. Now, the
Just
last,
a minute, just a minute.
last 3 lines of
Just a
the
minute,
paragraph.
just a minute, just a minute. Okay. Yes, please.
Now, my lord, this top paragraph, last 4 lines of the
Page?
page 41, the one paragraph 3.
Mm.
Firstly, I'll just draw your lordship.
Mm.
The line starting from since the said laborer, is the lordship got it?
Yes.
Since the said laborers were engaged by the contractor, therefore the provisions of section 10(2)(a)(1) of Industrial Disputes Act, and hereinafter referred to as the Act, does not attract. My lord, section 2A is something, section 10(2)(a)(1) is something else. So, their argument that since the dispute was jointly raised, they could not have come before the labor court under 2A by way of a joint petition. The reference, the dispute was commonly or as a group, they have raised this for termination. Now, my lord, even assuming under 2A, a reference can be made by a raised, a dispute can be raised by a group of workmen if they have the same cause of action. So here what they have done, all these persons were disengaged, the same cause of action. So they have come before the labor court under 2A. Because all of them were disengaged. The cause of action is same. So where is the bar?
No, what the learned senior council has submitted is that in the list, there are 23 numbers of persons, 23. And out of those, there are 2 of the respondents who are not even in the list.
Well,
and there are 8, therefore, who were parties in the list but are not parties in the application
yes,
filed before the labor court.
maybe once the dispute was raised for 23 number of people, some decided not to go for this litigation and they have found some other means, so they have left.
What about the two?
My lord,
5 and
these
13?
two, in fact, this plea is also not there in the written statement. For the first time, it has been raised before the High Court. So that question, whether these two were not there and these were not there before the Labour
No,
Court.
these are
Labour Court,
matters, these
No,
are
my
matters
lord.
of records.
My lord, Labour
Whether
Court
he
did
raises
not
the
have
plea or
the
not.
jurisdiction or means to examine that aspect. Just because two persons additionally they were brought in, will it mean that all the cases of all the other persons will
No,
go?
what about those two?
Maybe they have not, while raising the dispute,
No, see,
inadvertently,
see,
we could
two-
have given an explanation in the Labour Court why they were not there earlier and why they are now.
no, see, you are not, you will not be invited to give an explanation. It's your duty first. The onus is upon you to explain that you have followed the procedure in 2A. Maybe you, few of you have clubbed together, filed a common petition before the Labour Court, a Labour officer to adjudicate. It was not adjudicated, you filed application before the Labour Court. Okay, under 2A. Now that application which you have filed did not contain names of two persons.
persons.
So they never raised the dispute.
So at best, their names can be deleted. At best.
Well, may I just take leave for a few moments? Okay.
At best, their adjudication can be left or not addressed. Since this was not placed before the Labour Court, the Labour Court assumed that they were parties and accordingly answered. So, inclusion of these two extra persons will not make the entire adjudication bad. At best, these two persons case could not have been considered by the Labour Court. But since the management did not raise this issue, Labour Court had no occasion to examine this aspect. And as a result, my lord, all the workmen were presumed to be the workmen who raised the dispute, and an award was passed. And my lord, this is not even their pleadings in the written state. So what was not pleaded before the Labour Court, and if the Labour Court has not answered that, so for the management to raise this plea to contend that the award is bad for not considering this aspect is bad, my lord. It is, in my respectful submission, legally not tenable.
Yes.
Now, my lord, another argument was made that the issue of genuineness of the contract or whether it is a sham contract or not was not framed. Now, if your lordship takes up the issues framed, it is a broad issue, my lord. Whether the workmen number 1 to 15 are contract laborers engaged by the contract labor contractor. So it is a broad issue. Now, if it is established that they are contract laborers, then the issue goes. It goes against the workman. But while examining this issue, it is inbuilt that the issue of whether the contract is genuine or a sham is inbuilt in that issue itself. To answer this larger issue, that exercise has to be carried out fast, and it is only on answer, depending on the facts, the main issue can be answered. So not framing an issue will not make the award illegal or unreasonable. Now, on the merit of the case, my lord, I'd like to draw your lordship's attention to the provisions of contract labor regulation and abolition. Because, my lord, our case is that we are employees working under the principal or the management of Imami Limited. The defense of the management is that, no, you are working under a contractor. So the nature of contract is very important. Number two, whether the management can engage a contract laborer or whether the management is authorized under the law to engage contract labor is regulated by the Contract Labor Regulation and Abolition Act. So first, my lord, will see section 7. Every principal employer of an establishment to which this act applies shall, within such period as the appropriate government may, by notification in the official gazette, fix in this behalf with respect to establishments generally or with respect to any class of them, make an application to the registering officer in the prescribed manner for registration of the establishment. Provided that the registering officer may entertain any such application for registration after expiry of the period fixed in this behalf, if the registering officer is satisfied the applicant was prevented by sufficient cause from making the application in time. So first requirement is to engage contract labor, the establishment has to register itself before the registering officer. Now, if it is not registered, what will be the consequence? That is section 9. Because section 8 says if it is registered and if the registration is made and by fraud and manipulation of record, the authority can revoke the registration. Effect of non-registration. No principal employer of an establishment to which this act applies shall, in the case of an establishment required to be registered under section 7, but which has not been registered within the time frame fixed for the purpose under that section, and in the case of an establishment, the registration in respect of which has been revoked under section 8, employ contract labor in the establishment after the expiry of the period, re-employ contract labor in the establishment after the period referred to in clause A or after the revocation under clause. So it has to be a registered. Then, so for the contractors are concerned, they will have to acquire license, which your lordship will find at page section 12. With effect from such date, as the appropriate government may, by notification in the official gazette, appoint no contractor to whom this act applies shall undertake or execute any work through contract labor except with under in accordance with the license issued in that behalf by the licensing officer. Number 2, subject to the provisions of this act, a license under subsection 1 may contain such conditions, including in particular conditions as to hours of work, fixation of wages, and other essential amenities in respect of contract laborer as the appropriate government may deem fit to impose in accordance with the rules, if any, made under section 75, and shall be issued on payment of such fees and on deposit of such amount, if any, as security for the due performance of the conditions as well. So, my lord, the licensing authority will issue a license to a contractor specifying the work which he has to conduct. Now, my lord, in this case, lordship may come to the license of the contractor. I'll come to other parts also, my lord. Page number 17. License issued on 23/12/2005. Page number 17, which my friend referred as also.
Yes.
Now he has referred to the license only. Lordship will see at 2. The license is for doing the work of packaging, unloading, and material transport. So, my lord, this contractor has been authorized by the government to engage contract labor. So, for these types of works are concerned.
Yes.
Now, what is the agreement? Page number 20. Chandan Kakot. We are engaged in production of various Ayurvedic and cosmetic items. As per our discussion, this is I don't know, of appointing you as non-exclusive contractor on job work basis. So, my lord, this is not a contract for
Where are you
supply.
reading?
Page number 20.
Yes.
appointing you as a non-exclusive contractor on job work basis to carry out the activity of packaging of our various products from bulk to retail packs. So, my lord, it is a contract for the packaging work only, not a supply of contract labor. Scope of the work. I will not trouble your lordship. Lordship will find terms of appointment. Number one, you will be responsible to carry out the packaging activities as mentioned above within the timelines given by the company inside our factory premises, for which necessary arrangements have to be done by you from time to time. So, you will carry out the packaging work in the premises of the company by his own arrangement. So, it is an independent work. Number two, the required number of laborers would be decided and employed by you who would work under your supervision and control only. So you will engage people and you will supervise and control their work.
Yes.
And number three, the company would hand over to you the products, next page, from time to time, which you would accept under dated acknowledgement in a packaging register to be maintained for this purpose for necessary packaging activities as stated in the register. So we'll keep. So if we go by this agreement, it is a job agreement, not a supply of labor. It is an agreement where the management will give product to the contractor. He will carry out the packaging work and he will engage his own people and he will maintain a register. Now, in this respect, what is the evidence which has come on record? Lordship may come to page 58. Is the workman witness number 1.
Yes.
Sri Ghanoshyam Boisho, the workman was examined as WW1. In his deposition, he stated, I will not trouble your lordship by all these things. Your lordship has already gone through. This 8th line starts from the. The terminated workmen were regularly attended in production, manufacturing works of the factory as operator, raw material, feeder, line feeder, worker, etc. Now, my lord, the contract is for packaging work. The license is for packaging license, and for packaging license and the other associated works are unloading and loading. Now, this has come on record that these workers who were terminated or disengaged were working in production manufacturing unit. Now, if this is a contractor under the Contract Labor Regulation Abolition Act, and if these workers are contract laborers, then how come they are working in the production unit, my lord? And this evidence has not been rebutted, my lord. So,
I know that the 15 workmen of this case worked under the contractor. The name of the contractor is Chandan Kakoti.
my lord is reading.
And these 15 workmen, the cross part.
Yes.
And this 15 workmen were paid by Sri Chandan Kapoor.
So that is the sham contract. It is a camouflage contract, my lord. That is what the Labor Court has found. Because you don't have a license, the contractor does not have a license to operate in the manufacturing unit. He has a license to carry out the packaging and loading, unloading work. Establishment has the, if your lordship takes up Exhibit B, it is not annex, it is the certificate of registration of the company. It says that the company Imami certificate of registration containing the following particulars is hereby granted under section 7 subsection 2 of the Contract Labor Regulation and Abolition Act, Imami Limited. Name and address of the contractor Chandan Kakoti and name of
Mr. We may not be so technical, but there are certain kind of admission. My evidence on affidavit has been prepared by Basanta Kumar Kolita, and I put my signature as asked by him. I do not know about my examination in chief as it has been written in English. I am
which one, my lord?
cross part
Of
the same Ghanasham. 5th line.
from the award or from the main?
No, from the main file. See, he's made, I have no knowledge of English language. Okay.
My
My
lord.
evidence on chief has been prepared by Basanta Kumar Kolta and I put my signature as asked by him.
Yes.
He's not even said I've understood and asked. I do not know about my examination in chief as it has been written in English. No explanation that it was read out to me.
For the timing, then lordship may take the evidence of workman witness number 2, what he said.
To is Sahadev.
Shahadev. He had joined in the year 2003 as worker in production of Imami Limited. All the applicants were engaged with production activities under direct control and supervision of the permanent employees named so and so, so and so, so and so. In the production unit. My lord, here it is the fact, my lord,
I know.
that
Just a minute.
these workers were working in the
Just a
production
minute,
and
I know,
manufacturing unit.
Just a minute. On the basis of the. Yes, what is it?
My lord, in his evidence, he has stated that
Who?
number 1,
Okay.
that these terminated workers were working in the production unit and manufacturing works as operator, raw material fitter, line fitter, worker, etc. This part of the evidence has gone unrebutted. No denial, no cross-examination on this aspect by the management.
He doesn't even know what is written in the chief. He doesn't even know what is written in the chief examination.
My lord, in evidence before any court of law, we the lawyers prepare the evidence. Now, he's a poor worker. He could not have understood the
No, it's
technical-
not like that. Don't make out this kind of submission. He has to say that it was read out to me. I've understood.
But
in
I
my
have
language.
seen somewhere.
No,
the
never.
court in
No,
his-
he doesn't know. That is a very common thing. One person may not be conversant with English. He may not be even literate.
But so
he
far
has
in the
to
cross-examination.
He has
of
to say that
two-
it was read out to me in the language which I understood, and it is my version. Cross, he says he doesn't know about anything, the chief.
So whatever he has stated,
Maybe it's the trick of the lawyer, but
he was not
what-
a lawyer. The reference, my lord,
maybe-
is a trade union worker. He
maybe
was
it's
not
the trick of the
represented by a lawyer.
person who had made the cross examination. But what is there on records we cannot ignore.
But So for the witness number 2, he is saying that he is working in the production unit. Workman witness number 2 is one of the workmen in this case. In his deposition, he stated that he is the senior most worker amongst the applicant workmen. He had joined in 2006 as worker in production of so-and-so. Although applicant workers were engaged with production activities under direct control and supervision of permanent employees named so-and-so, so-and-so, and so-and-so. All are supervisors and so-and-so are all line leaders. They keep their attendance in a daily time card of which first page is printed as Chandan Kakoti, name of the worker, number of days attendance, and signature of the manager. So my lord, the time card, if he is an employee of the contractor, what the manager has got to do in keeping the attendance and putting his signature in the time card?
What is the name of PW of the
Sahadev Burman.
no, number 1? WW1?
WW1 is Ghanshyam Boisho. My lord, he is not a connected workman. He is a permanent employee of the establishment. He is not he is the permanent employee working in the manufacturing unit.
Oh, he is not one of the.
Connected. He is not a connected workman.
No, he is not one of the applicants.
Yes. He is not a connected workman of this dispute, but he is a permanent employee working in the factory who knows these persons and doing what sort of duty.
So even then, in that case, your version which you just told, that will not be relevant, because how he is being, what function he is discharging, he is not one of the affected party in
No,
the
my lord.
dispute.
He is deposing the fact that these persons are working in the factory, in the production unit as what?
No, apart from the
As
fact,
operator, raw material. Now, if they are working in the production unit, they are not in the packaging job. So, they are not in the packaging job. They are in the production unit. This much a person who is not a workman
Okay,
of the
okay.
reference,
proceed.
my lord.
Proceed.
If a person is not a connected workman, but is a person who is a workman of that establishment, he can depose or narrate the fact about the nature of employment of this person. This is a question of fact. If I see someone doing work in the production, he will say that these are the persons working in the production unit. Now, if they are working in the production unit, how come they be considered as a contract laborer of a contractor?
Okay, no, that we have already argued.
Who
Yes.
is engaged or licensed to do out some packaging work. So for the workman witness number 2, he has said
Witness 2 is a
connected workman, and in his cross he stated that evidence in chief is prepared by Basanto Kolita as per his instruction. Now, he has further stated in his chief cross, he knows witness Ghanshyam Boisho, an employee under management. So he knows Ghanshyam Boisho. So for witness number 3, Golab Bishas
Mr. Rachori, what is your case? Parthard. Okay, next case, which matter that
Yes, disproportionate.
yes. Mr. Chakraborty, how long? Finish it within 10 more minutes. Are you placing some relying on some decisions?
Not decisions, I'm just pointing out on
Okay.
facts.
No, but finish it as early as possible.
I do not have the evidence in chief.
Sahadev is a party.
Sahadev is a
And he
party.
says that his chief has been drafted as per his instructions.
Yeah.
Okay.
And witness number 3 has almost deposed in the same line as the witness number 2. So this is what I do not have the copy of the evidence. But one thing is evident from this, it is a finding of fact.
Was my question so crucial, Mr. Roy Chaudhary? Suddenly you have felt very hot. Oh, maybe we thought that our question was very crucial question. Relax.
Now, the time cut. Lordship will see these workers are given their attendance are marked, though in the time card they are shown as a time card in name written as Chandan Kakoti, but it is the manager of the company who is endorsing the attendance. It is there on the,
Where do you get?
it is there, this time cards are exhibits. I do not have the exhibit, my lord.
But your submission is the time card or
It is also a finding of fact by the labor court. The time
Time-
card is
time
endorsed or signed by the manager,
contains the signature of the
the
manager.
manager.
Yes.
So workman witness number 3, similar line that are working under the regular supervision of regular employee. But one thing is admitted,
WW3 is also
connected workman,
party.
Gulab Biswas.
Gulab Biswas.
Huh.
Gopi Biswas. Or Gulab Biswas.
Gulab.
Okay. 7. Sahadev is what? Sahadev is 11. Sahadev Burman.
Sahadev Biswas. Sahadev Burman, sorry.
WW3 is Gulab Biswas. Or 7.
Now, what is the projected case of the management? The management is saying, Lordship may come to paragraph 11 of the management witness Deepak Sharma.
Of?
The
Man-
award.
Okay. Deepak Sharma.
Hmm.
Okay, please read.
Denying the case of the workman, the management examined Deepak Sharma, Imami, assistant manager, Imami. In his deposition, he has stated that Imami Limited is a reputed company engaged in manufacturing of Ayurvedic medicines and herbal cosmetics under the brand name Imani.
Hmm.
Imami and Jhandu. The registered office is at Calcutta and have manufacturing unit at Amin. In Amingaon, there are 171 numbers of workmen who are working on regular. Besides the regular workmen, they also used to engage contractor for various activities as per the registration certificate dated 21/1/2004 issued by the GOV. The laborers in the petition claimed as workmen of Imami are not the workmen of company, since the said laborers were not engaged by the management and they are actually engaged by one contractor so and so who is licensed labor contractor. Now their case is as he is a licensed labor contractor. If he is a labor contractor, but his license is of undertaking works of packaging, unloading and loading, the license is not for supply of labor. Is a licensed labor contractor by virtue of an agreement entered with the said contractor for packaging various products. Now they are mixing it as if he is a licensed contractor for supply of labor and these laborers are undertaking the job of packaging and loading, unloading.
But what about page 20, the serial number 2?
What?
Page 20, serial number 2.
Page 20.
20. Employment of laborers.
Yes. So he
Read,
is,
please read, please read.
I have seen that he will engage his own labor to undertake that work.
Yes.
Now his work is to is the job of packaging, loading and unloading. So this is what he has been assigned with.
Yes.
And he has to undertake the job of this through his own people.
Yes.
Now, people who are not doing this job and who are doing other jobs, can it be termed as his employees? Because if I engage Mr. X to do the packaging work, so if the persons who are here before your lordship had been working in the packaging and unloading job, then things would have been different. I have a license to do the packaging and loading, unloading job. And the persons who are working in the production unit and doing the manufacturing job cannot be considered as an employee of this contractor because he has a license to engage person to carry out this job.
No,
only.
at best, it can be violation of the license condition.
So, my lord,
For that consequence under the labor
No.
abolition and regulation
No.
act will follow.
this condition shows that the contractor who is shown to be his employees are not actually the employees of this person, employer of this person. He can at best engage people for these works only. So any people who are not engaged in this work and doing jobs which are directly supervised by the employees of the regular.
Where is that materials to come to the conclusion is directly under the supervision of the management, not of Chandan, number one. Where is the document or anything to show that they are being paid by the management directly?
That is the sham contract. You show someone to be a contractor. Now, it is not a case where now, my lord, if under the contract labor regulation and abolition system, if someone is a labor supplier, things would have been different. He supplies labor to the management gets the work done to this, and this payment is made to the contractor.
That you have already said.
But it is not a case of supply of labor. The court has come to a finding that these people are working on casual basis. They were working not as a regular employee selected by means of a regular appointment, but they were continuously working. But they were working under the supervision of the. Now, workman number 2 has stated, although applicants were engaged with production activities under direct control and supervision of permanent employees named so and so, so and so, so and so. He has given the names of those persons who are supervising their work, who are workers of the permanent workers of the management. But their attendance is marked in a sheet which is in the name of Kakoti, Chandan Kakoti, but that is signed by the manager.
Okay.
Now, what the finding of the labor court is?
Yes.
Let us discuss whether the workmen have been able to prove their case on preponderance of probability. According to so and so, witness number 1, the terminated workmen are regularly attending in production manufacturing work of the factory. Clockship page number 64, paragraph 12. As operator, raw material feeder, line operator, worker, etc. So it is a fact, finding of fact recorded by the labor court on the basis of evidence of WW1, and this aspect was not denied or cross-examined by the management. Under the direct
This you have already referred. You have
yes, so
already
it is a
said
finding of fact.
it is by Ghonakanto.
Ghonakanto
Ghonakanto
Boisho. So this is the finding of fact. His evidence not rebutted by the management in the cross-examination. Sahadev with Bormon, witness 2 in his deposition, stated the workers are engaged with production activities, WW2, under the direct control and supervision of permanent employees, namely so-and-so, 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 per line. They keep their attendance. There is no independent contractor by the name Sri Chandan Kakoti under the management, and the Chandan Kakoti has not issued any employment letter or appointment letter to them. So if they are employees of Chandan Kakoti, no one could produce any appointment letter. Management or Chandan Kakoti did not produce any appointment letter showing that the fact remains, my lord, these people are working. The whole question is whether they are working under them.
Okay, without discharging your initial burden, can you shift the onus upon them?
No, my lord.
Can you say that you are required to prove, have your appointment letter by Chandan? Where is your appointment letter by the management?
Nowhere.
The first question will be
We
there.
are, we were,
Unless
had
you
we,
discharge your burden, the onus will
No,
not
my
shift upon them.
my lord, the management is not denying what is the factual position? These persons are working in in the premises of Imam. That is an admitted position. We are saying we were asked to we are allowed to work by the company. Company is saying, no, you are employed.
You come to the findings. The
My
12 is,
lord, the company is,
12 is not the findings. 12 is only the discussion on the evidence.
yes. Now the court has come to a finding, paragraph 14,
Page
66.
66. Okay.
I have gone through the agreement. Exhibit C. As per agreement, management appointed Chandan Kakoti as non-exclusive contractor on job work basis to carry out the activities of their various product, from bulk to retail pack. Exhibit shows that the license issued to the contractor Chandan Kakoti for doing the work of packaging, unloading and material transportation in the establishment of Imami. But the agreement was not for supply of labor. The management has failed to show that agreement was made for supply of labor. Admittedly, no appointment letter was issued by the management, but all the applicants were working under the supervision and control of the superiors, and line leaders were the permanent employees of the management. Now, my lord, what I am trying to submit before lordship, that these persons were working in the factory of Imam. There is no denial of that. Now, if they are working, the nature of appointment, no one is denying. Only the question is, we are saying we are the employees of the management, and management say you are the employees of the contractor. So if we are appointed as temporary employees or whatever, we are not on regular employment. So we do not have any appointment letter. We are allowed to work by the management. Now, the moment management says you are the employees of the contractor, then the contractor has to show and establish that, yes, you are my employee and this is how you are appointed and this is how I am here as a contractor. The contract is not for supply of labor. The contract is for carrying out a finished job. So how can they be considered as an employee, as a contract laborer under the contract? This is what the labor court has recorded a finding. The management has failed to rebut the evidence. Now, number 2 and 3 in their evidence have specifically mentioned the name of permanent employees of the factory under whose supervision and control they work. The management has failed to rebut the evidence of WW. Service were provided to the management, but not to the contractor. Mere writing the name of contractor in the front page of wage slip does not prove that the contractor, that the applicant and the labor contractor were right to regulate the employment in which the permanent employees were employees of the management. That apart, it is found that the contractor is not an independent contractor. Therefore, contract is found to be a sham and camouflage. Thus, it is abundantly clear that the management has economic control on the work of the workmen, and the real employer is the management and not the contractor.
See, you're relying on the witnesses, obviously. WW1 is not one of the affected party.
Yes.
But he can definitely, his competence as a witness, we are not doubting.
Yes, he
Anyone
can say as to
come
the nature of
the dispute. He has seen the particular workman. But, and so far as WW2 is concerned, Sahadev is one of the affected party. You come to his evidence, see what he says. Have you seen that there is no independent conductor, he say, contractor, it should be, by name Chandan Kakoti under the management of so-and-so. There is no license of contract labor so-and-so.
Because, my lord, in the context, to be a contractor.
Now, the existence of Chandan, which has been totally tried to be denied or obliterated.
We are not denying the existence of Chandan. We are saying that there is no independent contractor in the name of Chandan who has been licensed by the government to carry out the works in the production unit.
No, that is not the version. That is something adding words to his.
No, I'm not adding words.
No, what he has said, we have to read this. That, I'm reading this for you.
In the context,
No, no, it's not in the context. That it's an independent paragraph, paragraph 4. That you can check the records. That there is no independent conductor. Let us read what he has written. Conductor.
conductor,
By name, let us assume it's a bus kind of a thing. Conductor by name, Chandan Kakoti under the management of Mrs. Imami so and so as claimed. Chandan Kakoti was not issued any appointment letter of or employment card to us under the Contract Labor so and so Act. Even said Chandan Kakoti did not direct or supervise us in our works.
so Lordship will see that the management has engaged Chandan Kakoti for carrying out the job of packing and unloading, loading. He will have to do the work in the premise. So to be an employee of Chandan Kakoti, there has to be some materials to show that I was an employee of Chandan Kakoti. Now, if they were.
Chandan has himself deposed. What other materials do you need?
No, my lord, Chandan has deposed, but the
He was
Chandan has,
subjected
the
to-
management
He was
cannot.
subjected to cross-examination.
Chandan Kakoti is not authorized or is not having the license to carry out any work in the production part. His license is confined to, my lord, the packing part, packaging work only. Now, these persons, from the records available, it is clear that they were not working in the packaging part. If they are not working in the packaging part, they're working in the unit of production, so the license or Chandan Kakoti, even if he comes and says that he is my employee, he cannot, because he has no part, because he will have to do it in one part of the premises, which is not the production unit.
See, in his cross part, again, WW2. I'm just reading out. I have submitted my examination in chief on affidavit. The said examination in chief is prepared by Sri Basanta Kolita as per my instructions. Okay, no problem. Along with my examination in chief, I have submitted some documents, exhibits 1 to 6. But except exhibit 6, all other documents are photocopy. Doesn't matter. I know the witness, Mr. Sri Ghanesham Bushya.
WW1.
No, he is an employee under the management. I know Mr. Chandan Kakoti, the contractor. On the basis of daily time card issued by the contractor, Mr. Chandan Kakoti, we work.
If your lordship goes.
You are trying to make out a point that the license or the agreement of Chandan Kakoti with the management was confined only to packaging, and there are materials on record to show that the nature of duties where they are engaged, it goes beyond packaging. They were in production line, other things also. So therefore, that license will or that agreement will not govern their conditions of service. We have made that point.
And my lord, this Chandan Kakoti's time card, on the basis of which wages are paid.
That was signed by some manager.
Yes, it is
Yeah,
there
you
in
have
the record.
already said.
Now, Chandan Kakoti's license, with that license for the role of packaging and loading, unloading, management could not have engaged Chandan Kakoti for any supply work, labor work.
That you have said, that you have said.
So that is.
That was not for supply of laborers.
Yes.
Okay.
So that is what the labor court has recorded a finding.
Okay.
And that finding is.
That we have
based-
seen. That we have seen.
Now, my lord, the labor court, on this basis, labor court has recorded a finding that it is a sham contract. So they are not the contractor's employee, and it is not a case of supply of labor.
Okay.
They are the employees of the management. Once they are held to be employees of the management, what the labor court said, since they were not appointed on regular, through a process of selection, they, instead of reinstating them, which is normally a case where any person is illegally restrained, reinstatement with back wages, labor court has, instead of reinstatement, labor court has compensated them.
No, our argument has been made that even that 75,000 is not objective in nature. There is no discussion how
My
to
lord,
pitch the figure.
My lord, in all cases where compensation is awarded, it is a lump sum working out. Had they been reinstated in service, they would have worked for another many years. So instead of reinstatement and the time gap, a lump sum amount everywhere, lordship, even in high courts or other court, when such, it is not a compensation based on any calculation. It is a case where a person is compensated in lieu of his reinstatement. So labor court is empowered under the law to award compensation in lieu of reinstatement. So to give a compensation in lieu of reinstatement, a detailed analysis why I have come to that amount, that cannot be any formula to work out that. A person keeping his age, he is removed from service illegally, he would have been.
No, giving a uniform 75,000 to all irrespective of their age, their length in service, their periods left. Don't you think that this is kind of an arbitrary exercise?
My lord, in all cases of reinstatement.
No, it's not a one employee. There has to be some objective standards. It's not a high court. You cannot equate with
No,
the high
my
court.
lord, definitely not.
We
It
may
is
not have the, because labor court
Labor
is a
court is not high.
court of fact.
My lord,
Labor could have seen what is your wage, what is your age, or means make a basic kind of a exercise, not very accurate, and come to an approximate finding that this probably would have been your thing for the remaining period, minus your own personal expenses, something.
so my lord,
There's no discussion on that.
my lord, in the facts and circumstances, once the labor court records a finding that the retrenchment is bad.
No, that power we may not even question. Because under
retrenchment
11A, you have the power to give anything else.
is health. So to give, labor court has compensated them, and for that reason, the entire award, to the effect that it is highly unreasonable, irrational, for your lordship to strike it down under 226, my lord, in my respect.
No, he is not saying strike it down because of 75,000. At least some exercise, if first part we uphold that, yes, it's your retrenchment or your discontinuation is not proper, then for 75,000, he is trying to make out a case without a proper exercise of mind, application of mind.
My
You cannot
lord,
just
he has taken
come to a
certain
lump sum figure
facts,
75.
he has exercised certain, he has taken into account certain facts that these are poor people. Imami is a big company, for the big
Okay.
company, for a big company to compensate someone who has been illegally removed from service. 75,000 is not an unrealistic or an unjust amount. This is what the labor court, in my respectful submission, has perhaps taken note of. I'll once again, paragraph 18, Imami is a registered office in Kolkata. Imami is a renowned company which has so number of workmen who are working on regular basis. Considering the financial position of the company and balancing convenience.
Where does he reach? Where does he get the financial position?
My lord,
No,
Imami, my lord,
A big company can be in debt. We do not know.
my lord, at least
Maybe
from
there
the,
may be proceedings in the DRT.
my lord, at least this Imami in the labor court, Imami has not taken that we are.
No, there was
That,
no occasion to
that
take
is
such a
only for the okay, for their sake that we not raise any
Acha,
issues
my lord,
which are not connected.
my lord, is a renowned company. Obviously, no one can doubt it. Imami is a renowned company. He has so many workmen and financial position and
With
balancing
171 numbers of workmen, it becomes a renowned company.
regular basis, considering the financial position of the company and
Yes.
balancing the convenience and inconvenience of the parties. So a person who was illegally retrenched, if the labor court comes to a finding that they were illegally retrenched and in lieu of reinstatement with back wages, because we had pleaded that we were not gainfully employed anywhere during that period. The action is of 2013. This retrenchment and the
Okay.
award is of
Okay.
2015.
Okay.
And all these years, my lord. So 75,000 is not that an exorbitant amount for the management to make the payment, keeping in mind the status of the persons who were before the labor court.
Okay.
And another argument was advanced, my lordship, yes, my friend has argued, referred to section 200,
Retrenchment.
retrenchment. I'll once again take your lordship to retrenchment. Retrenchment means the termination by the employer of the service of a workman for any reason whatsoever, otherwise then as punishment inflicted by way of disciplinary action, but does not include voluntary retirement, retirement of the workman on reaching the age of superannuation, and he referred to B, termination of the service of the workman as a result of non-renewal of the contract of employment. My lord, here it is not a case where there was a contract of employment between the parties, employer and employee, and it has expired. So this 2BB has no applicability at all. So if anyone who is dismissed or removed from service for whatever XYZ reason, but not otherwise by way of this 4 conditions, then it will amount to retrenchment. I'm an employee of a company. I may be a temporary employee, I may be a permanent employee. Even a temporary employee who worked for 240 days in the preceding year has to be considered and given the benefit of retrenchment compensation if he is retrenched. So 200BB has no applicability in this present case. There is no contract. If there had been a contract of employment for a particular period, then this question of contract labor would not have arisen. 200 says a person who is termination of the service, means the termination by the employer of the services of a workman for any reason whatsoever, otherwise by way of a punishment or voluntary retirement or this. So there is no contract of employment. There is no question of expiry of that employment. They were working, they were asked not to come, or they were refused entry at the gate. So 200BB has no applicability so for this present case is concerned. Now, I'll just like to refer the.
I think if we have understood.
One more thing
correctly,
I'd like to just.
On 200, that was not his argument perhaps. He said that to apply the test, the application of 200, he has referred to the Supreme Court decision of Bengal and that general manager's case. He said there are 2 tests, and both the tests, the onus is upon the workman, which you have not discharged.
Yeah.
That was his argument. He's
No,
not gone
he's-
to the he's not gone to the exceptions.
No. So for the judgment he has relied is on the issue of contract labor, not on 200.
No, on the onus, on the onus of
The onus.
Yes.
because 200 will come only if he succeeds in establishing that there is an employer-employee
See,
relationship.
there if
So, my lord,
if you have read correctly, in 2011 1 SCC 635, there are 2 tests prescribed: who makes the payment and who makes the supervision.
Yes.
And
In
the
the-
onus to prove of both these tests, to overcome both these tests, is upon the workman.
Now, so far the supervision part is concerned, there are materials on record to show.
Okay, we'll see.
And another aspect, lordship will see the definition of contract labor under
Yes.
section 2B of the Act.
Yes.
A workman shall be deemed to be employed as contract laborer in or in connection with the work of an establishment when he is hired in or in connection with such work by or through a contractor, with or without the knowledge of the principal.
Yes.
Now, that hiring has to be through a contractor. What it says, in or in connection with the work of an establishment when he is hired in or in connection with such work through a contract. So, if he is hired for the work of work of the company through a contractor.
Hmm.
Here it is a case, they were working in the production unit and that hiring of the workers in the production unit through a contractor is not a material on record. A contractor who is in existence is a contractor who is engaged in packaging work only. That is why, so to consider them as a contract laborer working in the production
Now,
unit,
Mr. Chakraborty, I think you're stretching too much. You have made your point very clear that the contract was for a particular job. They have been engaged in some other jobs and therefore the agreement may not govern their services. That's a different argument that we may think over, consider. But here you are trying to say that they will not even come under the workman definition of workman under 2B. That is not, if they are engaged in that.
No. If I'm a contract laborer, what is the issue here? If I'm a contract laborer, then I'm out. If only I am held to be a worker of the principal employer, because all along the case of the management is that I am a contract laborer. Now, to be a contract laborer, who is a contract laborer?
Now, are you hired by Chandan or are you taken into the roles straight directly by the management?
My lord,
Great question. Were you hired by the contractor Chandan or were you taken on the roles by the management directly?
we were working under the management, but that
No, that's not the answer. Were you taken into the roles through the contractor Chandan or did you come into the contact with the management directly?
so for their case is concerned, they are the.
No, your case.
It is, my case is whatever the worker's case in the labor. code.
Yes. What is your case?
Worker's case is that they are the employees of the employer.
Show us that. Show us some materials.
Employees of the
That you
employer,
came into the
and their works were supervised.
No, you don't go to the other aspects. Your contact with the employer, show us the material that you are directly in contact with you came to the contact of the employer directly, not through some Chandan or anybody.
Workmen witness number 2 and 3. We are working in the
You
production.
have said
unit.
you are through contractor. You
No,
may be engaged in some other jobs. That's a different matter. We'll consider.
My lord, if I am through a contractor, then the contract between the principal employer and the contractor, there has to be some contract with regard to that particular work.
That you're repeating, Mr. Chakraborty. We
My
have
lord,
said
why
we'll
I am
consider.
repeating, my lord?
We are again considering, we are again repeating that yes, your argument is that the purview of the works goes beyond the contract, which is only a packaging. You have said that, we have considered. Okay.
So, under 2D,
Okay.
2B, contractor, if I
Okay,
am
we
to
have
be deemed to be a
anything new, please don't repeat anything new.
So I would like to refer to B, as per definition of
We
2B,
have read to.
I'm not a contract laborer because my engagement to the contractor is not established on this. And the contractor who is shown to be our employee is not a contractor engaged in that work.
Okay. Any decision?
My lord, decision,
Okay.
Right now I do
Yes,
not have.
anything?
No, that's all.
Okay. Heard. So and so, huh? The records of the Learned Labor Code have also been placed before this court. Hearing is concluded, judgment is reserved.
my lord.
Okay. Taking record to us, eh?
May it please. My lord, for
Just 2-3 minutes. From contract labor license to your license, it takes some time to travel. So that-
definitely.
give us the time to travel. এইটো লাগিব Yes, what is this item number?
My lord, your lordship may look into page 149, your lordship thought.
149. Just a minute. You are a Samabay Samiti and your by order of 10/3/2022, your license has been cancelled.
Right.
Fair price license. You filed an appeal which was rejected on 12/5/2023. And the allegation is delay in delivery.
Delay in delivery.
Not within that particular month, November, I think.
November.
So it was by the end of November. And this court in the order of 9/3/2023 had made an observation that the delivery was ultimately done, and that matter was referred back.
Back.
Now, after the remand, the impute order has been passed, again cancelling.
Cancelling, the ground is, my lord, that in both the occasion that previously when my written statement and subsequent my representation does not contain the same thing, it's not
It's,
corroborated.
it is not, there is, your
Not
stand
corroborated.
is going to be wavering.
One is
In one
labor
case,
is
you said that your daughter was ill.
other
In
is
the
a-
other, you said some workmen were not there.
shortage of
Shortage
labor.
of- Okay, remember.
That is the issue.
Okay.
My lord, now, my lord, if my lordship, the facts your lordship is well aware of, my lord, if I can take your lordship to section 15 of the Assam Public Distribution Order.
এখন আছে, 82 order.
Wait a-
Yes, we have. Yeah,
wait a-
public
wait a-
distribution
wait a-
order, the photocopy এখন আছে।
wait a-
90.
My lord, I can give your
Oh,
lordship.
we have. Don't worry. Oh, 82 order. No. Yes.
15, my lord, 15.
Order
Public-
15.
Order 15, Assam Public Distribution of Article Order 1982.
Yes, please.
If I read it slowly. If any licensed or his agent or servant or any other person acting on his behalf contravenes any of the terms and conditions of the license, then without prejudice to any other action that may be taken under the Essential Property Act, his license may be cancelled or suspended. The word is may be cancelled or suspended. The or your lordship is well aware of means alternative. Or suspended by any order in writing of the licensing authority, and an entry will be made in the license related to such suspension or cancellation. Both the time the legislature has said about or. And in 15(2),
Yes.
no order of cancellation shall be made under this clause unless the licensee has been given a reasonable opportunity of stating his case against the proposed cancellation by an order, but during the pendency or in contemplation of the proceeding of cancellation of the license can be suspended for a period exceeding 90 days, not exceeding 90 days without giving an opportunity to the licensee of stating his case.
Yes.
But during the pendency or in contemplation of the proceeding. But here what I find, my lord, because if I misappropriate PDS articles, that will be a more heinous crime. Here, delay of delivery. They have come with the instruction that other than cancellation, there is no other punishment. But what I find from the legislature's forward, the use may cancel or suspend. My lord, here it depends upon the crime that I have committed. The word is always or. So they have suspended me, then they have cancelled me. And it was 76 days. The period was 76 days from suspension to cancellation. So within 90 days, they have cancelled me. But my submission is that, is it not disproportionate? Because if I have misappropriated the article, then it would be a cancellation.
No, that part we have already delved and we have applied our mind. We may hold that this to be disproportionate, but in absence of any other prescription of penalty.
Here what I find, suspension is also a penalty. My submission may or suspend or cancel.
No, see, 15(1) is only with the aspect giving the power to suspend or cancel.
Yeah.
And if you cancel, you are required to give another proper opportunity of show cause.
Right.
And a suspension can stay valid for a period of 90 days even without an opportunity.
Right.
Now they have this here and see the language used, but during the period pendency or in the contemplation of a proceeding. Here, suspension was issued not as a matter of penalty.
Correct.
Suspension was issued contemplating that a proceeding will be held. And in fact, they have held a proceeding by issuance of a so-called notice, which you have
That
replied.
is why I want to place, my lord, subject to all my
Yes,
corrections.
yes, yes.
It was kind of a mischief in rule, my lord, because previously they have said or, may suspend or cancel,
Yes.
15(1). Then they have said contemplation. So there is, my lord, suspension is also a penalty, whatever. The word is may cancel or suspend. Twice they have stated about that, or. Or is an alternative, they may suspend and cancel, would have been different. Suspend and cancel, but here twice, and relating to suspension or cancellation. 51, both the times they have said or. This is something mischief in the rule, Mala. And my lord, my criminal case was given as a FR. And the only ground taken against me is this, that my lord, in my written statement and my subsequent representation after that High Court's order, that both the times it is not corroborative. But what I find, my lord, I have given a statement that there was, my daughter was ill, plus the two orders that your lordship will find in page 167. 167, my lord.
Of your petition,
Yes, my lord.
167.
Last paragraph, show cause reply 24/12/21. 24/12/21.
Yes.
And then written statement 20/12/5/23. And 24/12/21 are contradicted. But I take your lordship to both the letters. At page 200 in the affidavit, ma'am. But here I have stated
200.
page 200 in the affidavit, that is first letter 24/12/21.
Yes.
I have received the sub-allotment copy of office for normal. Then immediately on 24/11/21, I started to distribute. But physical illness of two neighbors of my society, it was not possible for me to distribute the rice within 11/21. And that was the reason given in 24/12/21. And my lord, the next show cause is at page
No,
201.
this part, Mr. Chaudhary, let us not go into this. This part we have already considered, applied our, we are only on the aspect of the penalty which can, any lesser penalty which can be.
But my friend has brought an instruction that they have no other penalty other than cancel.
Yes, Mr.
Article order, does not have any other penalty.
That we have seen, that is the plain meaning. Mr. Roy Chaudhary has tried to develop a case that 15(1) can be independently read without going to the aspect of 15(2). You can use suspension even as a matter of kind of a penalty and or cancellation. But if you go for cancellation, there is an obligation on your part to give a proper opportunity. How is that opportunity given? By giving a show cause notice and seeking their response. Now, it is not necessary that 1 has to be followed by 2. You will come to 2 only when you go for a cancellation. You can stop at suspension, suspend, and before 90 days is over, you can revoke the suspension. That can be, there is maybe a fine distinction between a normal suspension in a disciplinary proceeding, which is pendency, which is pending contemplation of in the contemplation of a DP, or maybe due to an arrest or behind the bars for 48 hours. Those are different concepts. Even for an arrest, a DP will follow, has to follow. But here you can stop with the suspension, revoke the suspension, and it gets automatically revoked if you do not draw up a proceeding within 90 days. under those circumstances,
Since it's still not a case of suspension, the suspension is, it can be revoked. It's a case of cancellation. We have applied our mind and giving him opportunity.
no, but the what he is harping upon,
If it is the case of suspension, or suspension or cancellation, if it is the case, then other part may not have been considered, my lord. If it is confined to the only on suspension.
no, he is trying to harp upon that
Maybe
the
a-
allegation
Allegation.
is not that serious, which may entail an order of cancellation. We are not raising any questions on the procedure adopted. You have adopted the fair procedure. Give him notice, sought his response, you find contradiction in the response, and hold that the suspension is valid. And from one point of perspective, you may also contend that the suspension, cancellation is proper because this amounts to essential services to the economically
Poor.
lower strata of the society, and even a day's delay may be
Yeah.
may have adverse consequences. Now here the delay was almost a month, but ultimately it's an observation of the court. Ultimately he has made the supply. Now what is the position? Are you
No, my lord, subsequent another one is running.
Well, supply was also not done by him, it was done by the officers, the officers, not done by.
How could I, my lord, when I am suspended, the other will take it?
no, that supply November last?
Yes.
Who had done it?
Under the authority of my lord, officers, under the
No.
authority of officers, my lord.
Where is
Yes,
it?
my lord.
Cannot be. The suspension order is of 13/12. He had
No.
made the supplies in some
No.
first week of December or last
No.
month of November,
No.
if you remember correctly.
My lord, at page 120, pertaining to mention that that with any bad intention, I have delayed the distribute of rice. If it was delayed only for the reason of illness of my daughter.
Okay, we'll try to balance this. We may not find too much fault with the decision-making process. And the version, that is one of the plausible views, but give him a chance. Okay, right. Third, Sri P.K. Roy Chaudhary, Learned Counsel for the petitioner. Also heard Sri M. Chutia, Learned State Counsel, appearing for all the respondents. Full stop. Please have your seat, Mr. Present writ petition.
Take up 11 of our affidavit, and we have stated that, my lord,
Page.
in the distribution of price to the remaining 11 now of FP sub agent by the Moon Call Inspector and Bottom Stock Property Inspector. In fact, the same distribution, in fact,
Page,
was
page,
distributed-
page.
my lord, page 5, my lord,
Of your-
173, my lord. Over,
173, yes.
paragraph
Where?
11.
Paragraph 11, yes.
With regard to above mentioned paragraph 9 of the petition document stated during distribution of NFS rights to the remaining 11 now of FP sub agent on 16/11/2021 by Moon Call Inspector and Bottom Stock Property Inspector. The Secretary Mohanpur Gaon Panchayat Samvay Committee was not present. In fact, it was distributed by them in absence of Secretary Mohanpur Gaon Panchayat Committee, who did not cooperate.
ठीक होगा so the present writ petition has a checkered history of which includes previous litigation also. Full stop. Para. The petitioner is a Samabai Samiti which was granted a fair price license being license number so and so, huh? Number to deliver. The said license was full stop. In connection with an incident in delay in distribution of NFSA rice to 11 numbers of fair price shop agents and some seizure made, Algapur PS case number 356/2021 under section 420/468 IPC read with section 7 of the Essential Commodities Act was registered. Full stop. Apprehending arrest in the said case, the petitioner number 2, who is the secretary of the petition number 1 committee, had approached this court by filing AB number 4311 of 2021, and this court, by order dated 7/2/2022, had granted anticipatory bail to the petitioner number 2. Full stop. It is also averred that in the said police case, final report was submitted. Full stop. Paragraph. In connection with the aforesaid incident, the department had issued an order dated 14/12/2021 suspending the license of the petitioner number 1 society. And the consumers were attached to a nearby society. Full stop. It was alleged that there were violations of clause 4, 7 and 8 within bracket 1 of the license. Full stop. Paragraph. The aforesaid order of suspension was the subject matter of challenge in a writ petition in WPC 7224 of 2021 filed before this court. Full stop. However, during the pendency of this writ, of the said writ petition, an order was passed on 10/3/2021 whereby the license of the petition number 1 was cancelled. Full stop. The aforesaid order of cancellation was the subject matter of the second writ petition, WPC 2332 of 2022. Full stop. Paragraph. This court had disposed of the said WPC 2332 of 2022 by order dated 9/3/2023 by directing reconsideration of the appeal by the appellate authority, namely the Deputy Commissioner Hailakandi. Full stop. This court had, however, noticed that the allegation was in connection with timely delivery of the PDS articles and wherein the delivery which was to be made within 31 November 2021 was not found to be complete. Full stop. The appellate authority on such remand had passed an order dated 12/5/2023 rejecting the same, and the orders of suspension as well as cancellation were upheld. Full stop. Para. Sri Roy Chaudhary, learned counsel for the petitioner, has submitted that the order of cancellation is absolutely harsh and shockingly disproportionate to the gravity of the allegation, to the nature of allegations leveled. Full stop. It is specifically contended on behalf of the petitioners that the allegation is not of any misappropriation, oblique defalcation of funds, oblique misrepresentation, but only relates to a slight delay in distributing the PDS articles. Full stop. He submits that for such allegation, the order of cancellation of the license as a whole is not at all reasonable, as it would amount to adversely affecting the means of livelihood of the petitioners and the members concerned with the petitioner number 1 submittee. Full stop. He submits that the commission received from such license is one of the main source of income, and there was never any intention on the part of the petitioners to cause delay in distributing the items. Full stop. Para. Coming to the explanations portrayed by the petitioners, comma, it is submitted that there were bona fide reasons for which the delay has been caused, and such reasons include illness of two workers of the petitioner number 1 society who were engaged in loading and unloading of articles, and also the reason that the daughter of the petitioner number 2 or 3, number 2, was seriously ill, for which she was required to be shifted to Guwahati for advanced oblique better treatment. Full stop. He submits that the appellate authority on both the occasions has failed to apply their judicious mind to the causes shown, and have rather taken a hyper-technical approach by coming to a conclusion that the stand of the petitioner number 2, that the stand taken by the petitioners was not consistent. Full stop. Para. By drawing the attention of this court to the reply dated 24/12/2021, as replies dated 24/12/2021 and 10/5/2023. 23 or 22?
12/5/23.
12/5/2023, yes. It is submitted that that there is no inconsistencies in the said replies, and the cause connected with the illness of the daughter which was inadvertently left out in the first reply, was also taken up in the second reply, and there is no questions raised on the correctness, oblique truthfulness of the said cause. Full stop. Para. On the aspect on the disproportionality of the punishment, comma, it is submitted that cancellation of the license is not only harsh, but the situation prevailing in this case would not justify such a penalty. Full stop. The learned counsel reiterates that the allegations are not of that serious nature whereby the severest of the penalty should be imposed. Full stop. on the aspect of on the aspect that the Assam public distribution of articles order 1982 does not prescribe for any other penalty, comma, Sri Roy Chaudhary, the learned counsel, by referring to clause 15 of the said order, submits that under clause 15 within bracket 1, comma, the authority is empowered to impose the penalty of either suspension or cancellation. And clause 15 within bracket 2 only lays down the prescription in case an order of cancellation is contemplated. Full stop. He submits that unlike the concept of suspension in a departmental proceeding concerning the service rendered by a delinquent employee, which is required to be followed by, which is passed in contemplation of a departmental proceeding, comma, suspension under the order of 1982 itself can be construed to be a penalty. Full stop. Paragraph. In support of his submission, comma, the learned counsel has referred to the case of Om Kumar and others versus so-and-so reported in 2001 so-and-so. Full stop. Reference is also made to a judgment of this court reported in 2014, 3 GLT 253 within bracket Santanu Medhi versus so-and-so. Para. In the case of Om Kumar recently. So in the case of Santanu Medhi, Supra, so-and-so. Para. Per contra, comma, Sri Chetia, the learned state council, submits that this court exercising writ jurisdiction would confine its examination only to the decision-making process and not the decision and not the merits of the decision. Full stop. He submits that there is no allegation made by the petitioners regarding any procedural irregularity, as admittedly, comma, before issuing the impugned order of cancellation, comma, the same was preceded by issuing a show cause notice. Full stop. He submits that such procedure is consistent with the requirement of clause 15 of the Articles Order of 1982. Full stop. He submits that both the cancellation order and the impugned order passed by the appellate authority assign reasons which are assigned grounds which appears to be reasonable. And have been taken by considering all the relevant aspect of the matter. Full stop. He submits that the replies dated 24/12/2021 and 12/5/2023 are prima facie inconsistent, as a new ground has been sought to be added with regard to the illness of the daughter. Full stop. He accordingly submits that no fault can be attributed to the decision-making process which has culminated in the order of cancellation of the license, paragraph. With regard to the submissions made on behalf of the petitioner on the severity of the penalty imposed on the ground of penalty imposed, whereby a ground of disproportionality has been tried to be made out, comma. The learned State Council submits that the allegation cannot be termed to be simple in nature. Full stop. He submits that distribution of PDS articles are mainly for the consumers who belong to the lower strata of the society, both economically and socially, and even a slight delay would have adverse effect on their livelihood. And therefore, it is not, and therefore the submissions made on behalf of the petitioner that only in case of misappropriation or defalcation that a license can be cancelled. Full stop. The London State Council further submits that no other penalty other than cancellation of license is prescribed in the Articles Order of 1982, and therefore the penalty imposed is justified and is consistent with the prescription of the law governing the field. Full stop. Paragraph. The rival submissions made by the Learned Council for the parties have been duly considered. Paragraph. The first of- before going to the issue which has arisen for determination, comma, it would be necessary to note the observations made by this court in the earlier round of litigation. Full stop. While disposing of the earlier
WPC. Which page? Start at page 149. WPC, is it 2332? Seven two two four. No, 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 it's 2332. 72 is another one. Both cases, while disposing of the earlier requisitions being WPC 72-4 of 2021 and WPC 2332 of 2022. Wide order dated 9/3/2023, comma. This court had made the following observations. A paragraph, page 150, actually. Italics page wrong. The remand was made taking into consideration that under clause 29, comma, an appeal is prescribed, which was in fact preferred and was pending consideration. Full stop. Pursuant to the said order of remand, comma, the impugned order has been passed by the Deputy Commissioner Hailakandi as the appellate authority on 12/5/2023. Full stop. Para. The learned appellate authority, while considering the case of the petitioners, has taken into consideration that the written version submitted by the petitioners on 2 occasions were not consistent. Full stop. It has been specifically recorded that in the written statement, comma, the secretary and the chairman of the petition number 1, while admitting the delay in distribution of the NFSA rice, had cited that his daughter had fallen ill on 13/11/2021, and for which she was required to be taken to Guwahati for better treatment, and had returned only on 19/11/2023, and therefore the delay had occurred. Full stop. However, comma, it is recorded that in the reply dated 24/12/2021, comma, the reason cited was that 2 laborers were unwell. Full stop. Para. The aforesaid observation of the learned appellate authority does not, comma, per se appear to be unreasonable or arbitrary, as such observations are based on the materials on record.
Full stop. This court has also noticed that the petitioners have been afforded a proper opportunity to defend its case, as admittedly a show cause notice was issued and the petitioners had submitted replies on 2 occasions. Full stop. In fact, it is not even the case of the petitioners that no proper opportunity was granted. Full stop. Para. This brings this court to consider the aspect of proportionality of the penalty imposed vis-a-vis the nature of the charges. Full stop. The charge in the instant case is delay in distribution of the NFSA rice for the month of November 2021. Full stop. This court in the earlier proceeding has already recorded that there was no dispute to the fact that the rice was ultimately distributed and the delay was which was distributed in the first week of December. 5th, I think. 5th of December, Mr. Chettiar? On 5/12/2023. Which is 5th, is it 5th? No, not November, it will be December. November.
16/12/2021.
No,
No, it is not.
not that. Was in the month of December.
Wonderful.
Month of December. Full stop. This court, December. Though timely distribution of PDS items which are meant for the economically downtrodden class of the society, economically and socially downtrodden class of the society is of paramount importance, comma, is of importance, comma. The penalty imposed of cancellation of the license, which is the severest form, appears to be disproportionate. Full stop. This court has also noticed that in the connected police case, comma, final report has been granted, has been submitted full stop. Though the nature of proof in a criminal case, no, it will not. Though that itself may not be a bar, may not be an absolute bar for proceeding under the Articles Order of 1982, comma, the said fact would certainly be relevant. The said fact would certainly be a relevant factor for consideration. Full stop. Para. This court has noticed that clause 15 of the Articles Order of 1982 contains two parts. And under clause 15(1), comma, a license can be cancelled or suspended. Full stop. The provisions of clause 15(2) is only in connection with the procedure to be adopted if an order of cancellation is required to be passed. Full stop. In other words, comma, unlike a disciplinary proceeding concerning a delinquent employee, comma, suspension of a license can itself be construed to be a penalty under the article's order. Full stop. In that view of the matter, comma, and more so, and more so when the said order, O capital, does not prescribe for any other penalty, comma, this court is of the view that the order of cancellation can be substituted by only an order of suspension, which was already passed, and the license of the petitioner number 1 society was under suspension for the prescribed period. Full stop. Para. Under the, in view of the aforesaid facts and circumstances and the discussions raised, comma, this court is of the view that on the ground of proportionality, comma, the impugned action which has culminated in the order dated 12/5/2023 would need interference, which is accordingly done. Full stop. The cancellation order accordingly stands interfered with, and the license of the petition number 1 society is directed to be restored. Full stop. Consequently, comma, the consumers who were attached to the petitioner number 1 society are directed to be again attached after restoration of the aforesaid license. Full stop. Writ petition accordingly stands disposed of. Accordingly stands allowed in terms of the observations made above.
Obliged, my lord.
It will be supplied, huh? That it fits.
The time for your lordship's writing is more or less mature. My lord, can I pray in regard to item 23? The,
Cancer hospital matter.
my,
That needs to be given priority, but this was a parted matter, sorry. What is the stage now?
my lord, your lordship may see. Lordship wanted to see the
Order
certified
sheet.
copy of
Order
the order
sheet.
sheet. That I have brought, my lord. That order has not been extended.
Why we wanted to look, have a look at the,
Because the status quo order was passed in view of the order passed by the reference court. Because of that, because your lordship will find the order dated 2/7/2021. Your lordship will find there. The lordship may look at page 2.
কালি পাৰিব, কালি পৰা যাব নে 2টা বজাত? কালি কিমান matter? Huh? Supply আহিব. Cannot be possible. You try on Tuesday. What time? Or Monday also you can
Yeah,
try. Monday, but this code will not be there.
My lord, I know it's possible, it will not be possible.
Tuesday,
Tomorrow or day after tomorrow.
day after tomorrow, Saturday.
Tomorrow, because I will be out of session.
Only
From
put the phone.
20.
কালি হলে মই চেষ্টা কৰিব পাৰিম আৰু দুটা বজাত upgrade. We have it at tomorrow. Tomorrow you
Right.
make a mention.
Right.
We'll take it about 2 o'clock.
Tomorrow at
2 o'clock. We will not reflect that in the cause list. It will come in the supplementary
Right.
list, but make a mention in the morning.
Alright.
Mr. Dev, you be here at 2 o'clock.
In the morning, we should.
Just make an upgrade so that others may know, but 2 o'clock it will
Yes.
take up this matter.
Much.
Unless there is some very urgent motion or something.
Right.
But we'll have it in the second half,
Alright.
beginning. Paucity of time,
After 2, my lord.
more paucity of time did not allow the matter to be taken up today. Full stop. Para, since urgency has been expressed, comma, list again, list tomorrow. Full stop. Learned Council are given liberty to make a mention for upgradation.
Much.
Other matters where interim order is there till today, can this to be extended? Mr.
Yeah,
Nath?
item 19 to 22,
Yes.
that PWD construction of roads. Lordship has directed us to bring the record. That record has
Which were the matters?
19 to 22
19
of the
to 19 to
supplementary cause list.
22 supplement, in the supplement. Lordship has heard the, as regard the
These matters, my lord, we are technically disqualified on the ground of
Construction of
misrepresentation of facts, my lord.
Bid capacity.
bid tender.
Bid capacity is not the ground, my lord. They rejected us on the ground that we have suppressed the work.
There are two
There are
two
three-
petitioners.
For
Yes.
petitioner,
One
yes,
company and one.
Yes, yes.
Yes,
You've got the records.
Lord, can I try?
Tomorrow, we have already fixed one matter. Tomorrow, there are 60 matters around. Have mercy on the court. Tomorrow, but next week will not. happen. Next week can try. But we thought we'd be able to dispose of the matter.
We pray that the matter may be taken up after 8th of February, my lord.
They have urgency.
It's a,
We don't mind fixing a date after second, but after they have urgency. And immediately on February, Mr. Chaudhary, I think.
Yes,
will
my lord,
not-
on that one,
but tomorrow, my senior is, otherwise I believe, we can.
No, but it's only for the records. If we can take up tomorrow, this will not take much time because we've heard this matter.
yes, my lord.
Lordship has heard-
Tomorrow, my,
And what about you? You for
I'm for the rest of the.
5 years. So what is your, I don't think you have made your arguments.
No, but.
Mr. Kaur is there.
Yes.
How long will it take?
10 minutes.
Tomorrow it may not be possible. Sorry. Sorry. Some situations, and if urgency was not there, you could have easily fixed a date. You try next week. Next week, Mr. Chaudhary will be there or not?
My
No.
lord, will not be there.
In fact, the petitioner has completed,
Huh?
petitioner has completed their,
Yes, that we know. No, if it goes before somebody else, a fair
Yes,
opportunity has to be given.
Lordship is not.
No, next week, next 2
take
weeks,
note.
not there. Next 2 weeks, we are going on vacation to Itanagar bench.
If not,
You are most welcome to join.
tomorrow,
Tomorrow we can fix, but we'll not be able to do anything. This matter is also, today one matter, CAV is there.
Let us try a plan.
File, last thought. File, same order DD. Paucity of time, Sridhinath submits. But Mr. Kaur is there or not?
My lord.
But he has to restrict his argument to 15 minutes, if we have the time. Sridhinath, Learned State Council, and Learned Standing Council, PWD, submits that the records are available, full stop. As the urgency has been expressed, list again, last document, list again tomorrow.
Item number 12, 14, I'll pay for a fixed date.
12 to 14 are what matters, Mr. Chaudhary?
My lord, similar matter. And health department, my connect friend is there. He has produced the records also from the last.
Okay, oh, those, that connected matter. Today there was some matter.
Yes, substitute was there, Lordship.
Yes.
But these are the all those, agriculture input, where
Okay,
Lordship
okay,
was directed to open the financial bid.
You have it on Tuesday next?
Any day convenient to
Tuesday,
us.
Tuesday. Tuesday, let it be decided because we don't want to hold back this. You know, paucity of time, huh? Tuesday. Interim order passed earlier to continue till the next day of listing.
Okay.
Item number 9 and 10, madam. Lordship will give me a fixed date, my lord. The matter relates to termination of a license, madam.
Court master will give a date.
My lord.
Termination of what license?
Fair price of license, madam. In fact, the other day, Lordship heard that matter.
Hello.